Supplementary list item number 20.
What? No.
20 to 20 supplementary.
Huh? Time being.
Sir, may I please allot time? Allot the matter pertains to a tender for 2018, where APTCL floated a tender for construction of 32 kV lines from one grid substation to a substation under Kokraja Electric Company. We participated in the tender. We submitted our bids. 6 bidders were declared as technically responsive. We were one of them. On 28/1/2018, the price bid was open. We were declared as L1. Thereafter, the LOI was not issued to us. Till 8/4/2018, the LOI was not. On 9/4/2018, we got to know from reliable sources that the LOI was issued to the L2 mine, respond number 5 here. So when we approached the authorities, we were told that LOI was not issued to us because our bid was rejected, because our rate was outside the viability range. It was 16% below was that of the estimated cost. The LOI that was issued to the L5, L2 minor, that was not uploaded in the tender portal minor. The decision was not uploaded in the tender portal. We were not informed whether a bid was rejected or accepted. Thereafter, we filed this writ petition minor on the 10th of April. On the 11th of April, the decision was updated. And my lord, in the tender document, nowhere the estimated cost is mentioned.
On 11th of April?
2018, my lord. On 10th of April 2018, we have filed this writ petition. On 11th of April of 2018, the tender summary report and the decision was updated at the tender portal. Thereafter, my lord, but the thing is, my lord, the estimated cost is nowhere mentioned in the tender document, my lord, or there is no calculation that is given how to derive the estimated cost or how to determine the estimated cost. Although the viability range is given, my lord, which is at page number 39. My lord, may I just point out one thing, my lord? There's a stay operating, my lord. My instruction, subject to what my lordship holds, my instructions are the APTCL wants to withdraw this tender and issue one afresh. I'll just pay that.
Mr. B. Chaudhary, the learned counsel appearing on behalf of the APTCL, had placed before this court a communication issued by the Chief General Manager, bracket PPND, bracket close, APTCL, to the effect that the tender which have been assailed in the instant proceeding, that is for execution of the work of inverted comma construction of new 33 kV line from 132/33 kV Gopigaon Bilasipara DSS to 33/11 kV Sapatgram SS and 11 kV extension line from Sapatgram 11 kV Town Feeder up to Nandipara bracket package Roman 2 would be withdrawn and fresh tender would be issued. In that regard, the said communication was placed before this court, which is kept on record and marked the letter X. The learned counsel appearing on behalf of the petition, Mr. So-and-so, submits that in view of the decision so taken by the APDCL authorities to cancel the earlier tender process and to float a fresh tender process, he would not like to press the instant writ petition. Accordingly, the writ petition therefore stands closed in view of the above letter dated, in view of the communication kept on record and marked with the letter X.
Interim order.
The interim order, the respondents, in view of the withdrawal of the instant writ petition, the respondents are given the liberty to float a fresh tender in respect to the above mentioned work.
I'm deeply aware. Look, there is an interlocutory application.
Interlocutory application stands closed.
I'm deeply aware. Make it. The petitioner herein is challenging the order dated 14/5/2018, whereby the respondent number 5 was allowed to shift IMFL stock to the petitioner's locale.
Huh?
The
Respondent number 5?
respondent number 5 IMFL of Lordship will find the impugn order at page 21. Lordship takes up the compilation melody. Page 21.
Yes.
Malad. This is an order, Malad.
Who are you?
Malad.
Who are you?
Malad, I am the development committee, Malad, constituted by the occupiers and the residents of the neighborhood of the premises.
Which premise?
Malad, the IMFL of Malad, where it is located, where it has been done.
Pragjyotish Nagar, Bhutanagar, Ward number 1.
Yes. And Rule 295, Malad, this is a sanction under a Rule 294. 295 gives the right to the neighbors and occupiers to place their opinion in respect of the shifting of or an opening of a IMFL shop. May I just point out the rule first?
Yes. Yeah, some
Assam Excise Rule 2006. In page 21, your lordship finds in pursuance of the government sanction,
Old one, your lord.
27 April.
Assam Excise Rule, the old one. Old one. The Assam Excise Rule is referring to the old one.
Why old one?
2016. Your lordship will find the page 21, the sanction order 27 April 2018. In page 21. Now, your lordship will find the sanction order at page 74. This is a sanction order Rule 294 of the 2000. Page 74 of the compilation.
Yes.
With
But this is the same thing.
Well,
yes.
Yes. Therefore, 2016.
But this is of 2018.
My lord, at that point of time, 2016 was rule was in place.
Yes, this is the 2016. What new rules have come in?
Now new rule.
What new rule? This is the rule.
25,
As I know, after the 2000 Act, this is the rule.
No, it has been amended.
Amended, your lord.
When?
It was amended in 2020, 294 that is harping on. This was amended of 2020. And 295, a new clause was inserted in the year 2018, your lordship. 31st December 2018, wherein the criteria of 75 meters.
25, objection.
Yes, the Lord. My Mary 294.
This was inserted in on 31st of December
December
2018.
2000.
So as on that date, this rule was not there.
No, not that.
So we have to read only 1 and 2.
1 and 2.
One.
Tell me.
Objection from local bodies and following persons will be considered. In case of corporation, municipality or town committee, the corporation, municipality or town committee concerned to which the proposal relates, and the neighbors, occupiers and residents of the neighborhood of the premises. So these petitioners, these are the residents and occupiers of the neighborhood of the premises involved. But none of them opinion was taken. The only NOC,
The opinion, where is the question of opinion? There is a
Well,
question of objection.
objection.
Objection, why? Where you objection is a thing which you have to object.
No, we did not even know that there was a sanction given to the IMFL South to ship.
So they are to required to put it out there in the notice board or something to the effect.
Malot, the rule does not say so.
No.
There is one High Court judgment, Malot, where it says that as the rule does not say so, the authorities should publish in the newspaper or in a public notice so that the persons concerned who has a right to give their
Show
objection.
me that.
Para 4 and 6.
This was given at that point of time.
Madam?
This was given at that point of time when these rules were not enforced.
Madam.
Then
It is a perimeter rules, Malot, in same as
Perimeter.
2016.
when the legislature have not thought about it, why should this court take note of all these things? It's not applicable. Now kindly see. You have a copy of this judgment?
I had one copy.
Give it to him. They were referring to Rule 191.
Madam.
191 says after carrying out a local inquiry.
Madam.
Where is that? Out here. How do you imply that? Here is a case of objection.
Says under Rule 289.
Yes. Where is it?
289. The liquors of any description should not be located at sites to which neighborhood
Object.
on grounds which upon inquiry appear to be reasonable and free from malice or ulterior motive. And if your lordship now reads 294 together. The opening, shifting and closure of any licensed premises shall be done by the district collector with previous sanction of the state government. Such opening, shifting and closure shall not be granted unless it has been satisfactorily established by a local inquiry that proposed action is necessary in the interest of public, until any objection which have been filed on subject have been considered by the district collector, and unless the application fee is prescribed is paid. So, my lord, 294 makes it clear, my lord, that before granting the or before giving any sanction with regard to opening, shifting, and closure of a IMFL shop, the authorities has to do an inquiry, and in that inquiry, the authority has given a power under 289 to decide whether the objections or opinions which have been given by the public or the neighborhood, whether it is genuine or it suffers from malice. So here is a case, my lord, while when this sanction order was passed on 14/5, 17/5, when the respondent number 5 put a banner on this shop, the neighbors, occupiers, my lord, of that locality, they came to learn that there is an IMFL shop. They opposed to that. Thereafter, the respond number 5 have closed the shop for a while. They approached this honorable court by a repetition where petitioner number 2 were made a party, but at the motion stage, that repetition was disposed. My lord, kindly find page 30, the earlier order.
What is the difference between the prior and the previous one? Because this you are reading
My lord,
294
My lord.
has been amended in 2020.
Here the
What is the difference between the two?
here now in the new rule, a distance has been given. My lord,
No,
only
no,
the
no, no. 294
My
does
lord.
not say about this. 295 says about
295
it.
says it.
294 say the opening, shifting, and closure. Kindly see.
My lord.
Opening, shifting, and closure of any licensed premises shall be done by the AIA with the previous sanction of the state government.
Right.
Such opening, shifting, and closure shall not be granted unless this is.
Yes.
But however, now, presently, the shifting is not there.
Yes. Yes. Because
The difference is now, the legislature does not require that for the purpose of shifting, 294 would not apply.
possibly because of in the amendment, there is a restriction in respect of shifting.
Why?
There is a part.
Huh?
Okay.
Because 294A was
A
brought in.
was brought.
The shifting of a license for wholesale or retail bank from one location to another within the same shall be allowed by the except it is due to the correct. No interdistrict the shifting or shall be subject to the fulfillment the now panchayat to ensure the post necessity from a distance specific and other criteria as per
Hmm.
the except for me. So here 294A does not say anything about objections.
294. Okay.
So after 2020, the concept of objection as regards shifting is gone.
No, 295 stand as it is. Only difference in the new amended rule is there is a distance, the radius has been specified. Earlier in the earlier old rule,
See, 295 is in relation to objections.
it has to be
Objection.
in my respectful
But the inquiry which is required to be made would not be applicable in respect of 294 for shifting.
now
Even for 294A, what is inquiry which is being mandated as per 294 is no longer required.
now 294, 295 does not say anything other than who has the right to give an objection. 294, the inquiry will have to be read, my lord, with 295 in my respectful submission, because 295 gives a right to those persons, acknowledges his right, who has the right to object in the inquiry.
Now, therefore, 295 would only apply in the case of 294.
In the case of 290.
After 2020,
294A, it doesn't say anything.
295 has no meaning.
No meaning.
Isn't it the correlate? So after 2020 to 2025 has no, the question of objection is become for purpose of shifting is no
appears.
longer there.
It appears.
So then,
But here, this is an sanction under 294 of 2016, my lord, prior amendment.
at that point of time, it was required
It was required.
for shifting. Now, whether they had the local inquiry.
No.
How
They
do you
had
say?
Because my lord, the earlier the records were also produced. This matter was heard at length for a long time. Matter the records were produced, there was nothing on the record which shows that they have done any inquiry. My lord, if your lordship will
Yes,
find,
Mr. R.R. Gogoi,
Lordship,
no inquiry.
that inquiry is with page 129, your lordship, the compilation. Your lordship.
they are pointing out page 30, second correct.
Page 129.
129.
130,
129 is, this is Human Sham's order.
the compilation, your lordship. The
What compilation? There, no,
129.
this is the compilation which is there. 129 is Justice Human Sham's order. One case has been registered. It's a bail to one Bhaiti Chaudhary.
Before, before
Whose
that,
affidavit?
It is in the affidavit of the respondent number, excise department.
Excise department.
What is the affidavit in of the respond number 3?
Yes, your lordship, excise department.
Additional affidavit. No, sorry, man. It's an additional affidavit of respondent number 5.
Additional affidavit. Yes, page.
The internal page, it will be 6 months, but now the first selection.
This is the inquiry.
Yes, ma'am.
It's 125.
We
Oh,
are
no.
relying on a compilation made for everyone.
But my compilation says 125. Anyway. Form of inquiry in the matter of the prayer
Yes, sir,
for
doctor.
shifting.
The next page, your lordship.
Page 30.
Number of existing shops, there is only one number of IMFL off shops in the locality which falls Kamrup of the court. No IMFL off on is there within a distance of 100 meters.
Your part, the shifting was done pursuant to a Supreme Court that order. This shifting was done pursuant to the Supreme Court order. We were required to shift from the highway from Boruadai. We were placed here. But now the Supreme Court order is also not applicable because this has now become a municipality area. Initially, because lots of got shops closed down near the Delhi Aero City and all those companies. So that was the matter. And now new shops have also come
You
up.
were not the person. You were for the other one, huh? Which led to the closure of many shops. Instrumental. Yes. So there was this inquiry.
Your lordship will kindly find page 130.
Yes, what is it?
What they want to say, my lord, the undersigned visited the person concerned, visited the proposed site and met some of the neighbors in and around it. And they say they also issued no objection certificate regarding the shifting. Now your lordship will find the no objection certificate at page 35.
Page?
Page 35.
Of the writ petition.
But I'll leave it. Page 35 with this.
Yeah.
This is an NOC, my lord, which is taken as an from the neighborhood people. Now, among these 18 people, my lord, 7 people, they are not even from that locality. 4 people not known from where they are. I'll show that, my lord. They have disclosed their addresses also. Page 35, your lordship finds this NOC. 36 is the Varnapur.
Yes.
Now, when there was a resentment in the public, my lord, in that locality, there were complaints filed. These signatories, my lord, they have individually filed a complaint at page 48 before the authorities that their signatures were fraudulently taken. They never gave any of NOC in respect of shifting of the IMFL. Page 48, your lordship, right?
Now tell me, within your locality, is there any IMFL shop?
No.
Why you are saying so? Because here it says that there is another shop.
That is in the national highway, which is 4 kilometers highway.
No. Within 100
Within
meters.
100 meters, there is no shop.
There is another shop. There is a mention of there in the inquiry report at page 130.
There is a shop, your lordship.
7 minutes.
There is one IMFL shop in the locality which falls under Kamrup Metro. Of course, no IMFL is there within a distance of.
Huh?
100.
Of course, there is
Of
one
course, no IMFL off
number
on
of IMFL off shops in UF. There is, of course, there is no IMFL off oblique on is there within the distance of it.
100.
In the locality, there is.
No. If your lordship find from there, in fact, your lordship had this matter and directed us to file an additional affidavit.
Hmm.
That additional affidavit,
Hmm.
where there was some allegations level that there are two more shops
Hmm.
in that locality,
Hmm.
but I have clarified that in page the additional affidavit filed on 7 June 2022.
Yet, kindly come to Annexure A of the additional affidavit. I think it will be, I don't know your page. There's a photograph.
Yes, we have given the picture of those wine shops.
This wine shop, which is whose PN wine shop is yours.
Yes.
PN wine shop. Where is the other wine shop?
Vintage.
Where? Where is the photograph?
Yes. Yeah.
Vintage, Annexure C.
Vintage. And MP.
These are all within the same locality.
Yes, after that also another
In fact, from-
government went to advertise and there was another new shops open up even after shifting. And now also they are proposing to establish more shop in that area.
If your lordship takes up my additional affidavit for
Huh?
my additional affidavit filed pursuant to your lordship of 7 June 2022.
Yes.
May I read
Hmm.
para 7 of that affidavit?
Yes.
The deponent begs to further submit with regard to the contents of the respondent 5 made before this honorable court during the hearing dated 7/4/2022 that there are two other wine shops located in the Kotanagar area. I'll mark this area, Kotanagar area within ward number 1 of DMC is out and out complete. The two wine shops which are located in the service lane of National Highway 37, among which one, namely NP Wine Shop, is located opposite to Radisson Blue Hotel next to Dhaba called Eglantyne, and the distance from Pragjyotis Nagar area, the area where this stop is located, is approximately 3 kilometers. And the other wine shop, namely Vintage Wine Shop, is located 500 meters away from the above mentioned wine shop, the NP Wine Shop. This in the same service lane, which would be approximately 3.5 kilometers from the Pragjyotis Nagar. And therefore, these two wine shops does not fall within the locality of Pragjyotis Nagar area or its nearby areas, DG Colony, Koti Doimati Nagar, Onirban Nagar, and therefore the question of raising any objection against the aforesaid two wine shops does not at all arise, as because these are the two wine shops are not located in the residential areas but in National Highway 37. Now, your lordship will kindly take up the additional affidavit wherein they have brought one document of the excise department, additional affidavit of the respond number 5.
What are these photographs? Annexure 3 of your that affidavit?
My affidavit.
Hmm.
Here, there was one allegation level. We said that this is a residential area. They said, no, there are other shops also.
Hmm.
And therefore, we have brought this. And we have contended that these are the shop corners which are recently been opened for the daily uses of the people of that locality.
Hmm.
That does not make it a commercial area. Be that as it may, your lordship find the additional affidavit that is filed on 14 December 2022 by the respond number 5.
That with the photographs.
No.
Photograph.
Once
Yes, that is the one with the photograph.
the 14 December 2022,
On the 14 December 2022, there is another one. Yes, yes. Sorry.
now if your lordship find Annexure A,
Hmm.
your lordship will find the existing shops and the proposed shops which the excise department want to open.
Hmm.
Here your lordship will find Kotanagar Maligaon area
Where? Page
in Annexure A, my lord. The compilation
Annexure
page one-
A. Yes.
162.
Yes, tell me.
Here your lordship file Kotanagar Maligaon area
Ah.
2.
2. Yes.
These are existing. That is one NP, which I have said, my lord, 3 kilometers away from us, one and other Vintage 3.5 kilometers away from us. So this Kotanagar area has 2. This Pragjyotis Nagar area does not fall under the Kotanagar. And they are now proposing to open on one more.
Hmm.
Had this 3 wine shop in one area, then the existing wine shop would have been 3.
Now you say that there was no inquiry.
There was no one.
Where you filed objections.
The signatories. we
Now, have
had
you
objections.
filed any
Yes,
objections?
yes. We have filed several complaints before the superintendent of excise. In fact, my lord, if your lordship finds page 48 for a
And
moment,
what is the stand of the superintendent of excise
my lord, for a moment, my lord, page 48 first.
of your
Uh,
petition?
48 of my page.
Yes.
Here, my lord, this is a complaint filed by the signatories who has given the NOC.
Hmm.
Now, if your lordship finds serial number 4, mein, Tomal Chakraborty, so serial number 3 first, Vishwanath Chatterjee, my lord, find his address, your lordship will find Gosala. Tomal Chakraborty, your lordship will find his address is 40 Doimati now. Sukanto De, serial number 5, 40 Doimati now. Serial number 6, 40 Doimati now. Serial number 7, 40 Doimati now. These are the persons, my lord, who are not even a resident and occupiers of that locality. Their NOC was taken as an opinion of the locality who has for granting the sanction. And pursuant to this complaint, the excise department called all the
Just 1 minute,
signatories
just
to a
1 minute.
hearing.
Where is the no objection?
My lord,
Where is the no objection? Here.
page 35. In the no objection,
What do they say? They say that they didn't sign these documents.
my lord, they say that they are some say that their signatures were
No, no,
sent
some
to
cannot say. All signed one
one
document.
document.
So they cannot be
No,
some saying
but,
something.
No, he might have approached that sign this document. I'm opening a paint shop. One says that their
Where?
signature,
Where have you mentioned that?
my lord, in their
There only one letter is there.
no, page 51 are the statements.
Because the signatures appears to be similar.
Exactly. Sir. But yes, they don't dispute that it was not signed by them. They
There.
say their signatures were obtained fraudulent.
Why? To me that we the undersigned would like to bring to your kind notice.
Please,
Owner is known to us. That's why according to the request made by so we agreed to sign in favor of a wholesale shop in our locality. That is paint shop and others. That's surprisingly we have come to know from a reliable source. Now, did you place this before the authorities?
in fact, after this complaint, page 50, the authorities called all the signatories to for a hearing.
Page 50.
Page 50 of the report.
Yes.
All the 17 signatories.
Then what happened?
They submitted their individual written statement, my lord, from page 51. In fact, the inquiry report was submitted to DC allotment at page 100.
Now kindly come to page 51,
Page
the
51.
second paragraph.
That, sir, of late I came to know that Pradeep Kumar Nodi misused my signature along with other residents of our locality to open an IMFL shop in our locality.
No. On the paragraph before that.
That sir, Pradeep Kumar Nandi is a resident of our locality, is known to us since long and often used to visit our house as a family friend. One fine day he came to me and disclosed his intention to start a liquor business for which he required my signature to comply with a certain departmental procedure. However, the actual place of business was not disclosed. He also informed that some of the persons known to me have also agreed to help him to start this business. I therefore, on good faith, signed on that very paper.
Now,
Now,
if we read this with page 48,
Well,
that sir, according to the request, we all agreed to sign in favor of setting up of a wholesale shop.
Malat, I
Then how do you?
we as a petitioner, Malat, we are not concerned. The inconsistency of this stand that has been
No. Your entire basis of your case is this.
No,
Then what is your case?
my case is that these are the people who have signed this NOC. These are not even a resident of that locality.
How will this court know?
Yes, Malat, their own document. Page 51, your lordship will find the down below their addresses.
No, these addresses, if somebody must have put it by hand, how do I know that he is not a resident of there?
There is no denial on the affidavit also to that statement in by repetition.
Kindly see this particular second paragraph, the
Madam.
third paragraph.
Madam.
That, sir, of late I came to know that Sri Pradeep Kumar misused my signature along with other residents of our locality to
Madam.
open our in our locality. Then how do you say that?
No,
If he is saying that it is so that he's not a resident out there, then why does he mention this?
but this same person, my lord, your lordship will find.
No, Mr. Kaushik, kindly appreciate this.
My lord, yes,
You on one hand say that he is not of that locality.
absolutely.
Then this is the allegation which is being made out here. You enclose it as a document out here, wherein he categorically says that the IMFL song is in his locality.
These documents which I annexed with this repetition, my lord, only to show that the NOC which was the basis for granting and sanction, these NOCs were given by the person who are not even a person of that locality. 295 makes it very clear, my lord. It has to be,
This is exactly the same, page 57.
yes,
It's the same.
and these
People have
people, my
just
lord,
signed it.
when there was a resentment, my lord, will kindly appreciate myself. When there was a resentment in that locality in respect of the shifting of the shop, my lord, these people, they realized that no,
Kindly come to page 58. This person is from Pragjyotispur Nagar.
Yes.
Apurva Boisho. It's the
No,
same.
yes,
It's the verbatim use of the same language in all these pages. Now what has happened after that?
after that, my lord, the excise department has conducted the inquiry. They have prepared an inquiry report. Their affidavit page, paragraph 5, my lord. Affidavit of deposit not, my lord, the superintendent of excise,
Page,
filed on 6/2/2020.
running page.
Running page. Comparative for nine.
Yes.
Madam.
Fine.
Paragraph 5.
Allowed us to inform and commit earlier to a new factory at the depot that during the inquiry the license is on it signed by 17 residing in the same locality. Then thereafter
Yeah, upon
after
receipt of the
completion
complaint,
submitted report to the commission.
from the report of the superintendent excise.
So the excise authorities are supporting you.
Yes, because there is a public complaint and they know that they have never done any inquiry.
So what is your decision now?
The matter has been forwarded to Commissioner of Excise. Since the matter has been, this inquiry report has been forwarded to Commissioner of Excise. The matter is sub judice, the matter, there has not been decision taken yet. The last occasion I proposed that let the commissioner take in all the relevant facts and circumstances of this case. It's like hearing him given to both of them a lot, given the petitioner as well as the respondent a lot. Because some of them have signed the NOC, they say we didn't know. And some have said we were not in locality because at that point of time, the distance by the 75 meter was not there. To get the NOC, now there's and we're
No, now the question is different again. Now, for shifting, the question of object 75, 295 doesn't apply.
Yeah, exactly.
As of now, to the 295 doesn't apply.
apply.
So, for shifting, there is no objection.
There is no
Only for the purpose of opening and closure, you need objection.
yes, a lot.
That's all.
That
So, as of now, that is it. But this inquiry report, let it be decided by
Yes,
them.
sir.
Why should this court entertain this type
Yes,
of
sir.
matters now? Giving liberty to both the
Both of them
parties,
to
the
open, yeah. Because
commissioner shall hear both the parties
yes, a lot because
and then pass appropriate orders, and any party being aggrieved shall approach
Shall
this
approach.
court.
Malak.
I think that is the best.
Let me, they want that, because why? Malak, your lordship will see the. just
No,
one
no,
point
no,
of-
no. You see, when the matter is
I have-
now
I have
pending
kept it-
before the authorities, why should this court take up this matter?
My lord, when I will go to the deputy commissioner's office, my lord, I will go along with my son, say, they will come with 50 persons and they have pressurized all this person to sign in blank papers. I will prima facie show to your lordship. Your lordship will kindly see how they have done it, my lord. Then I have kept in mind your lordship's proposal, but your lordship will kindly see the
No,
first
but
NSC
Mr.
Act
Kumar,
page
no,
35.
Mr. Kumar,
Yes, my lord.
kindly appreciate one. On certain facts, the authorities are presently dealing with.
Yes.
The authorities have not come to an opinion. It is his writ petition.
Yes.
Who has come? Who has? And he has come before this court. So, as the authorities are already dealing with it, for this court now to deal would not be proper. If it is your writ petition, I would have taken it otherwise. But it is not your writ petition, it is his writ petition, for which he, at best, when the authority, if he is asking that for a direction that the authorities, I should direct the authorities to decide, then I would not have.
Yes.
But now that is not the issue. The authorities are dealing with it. Because of the pendency of the matter, the authorities are not taking any action. Let the authorities take a call on that. And if any person is aggrieved, come before this court.
My lord,
You will be it is very nice for you to come and appear as a petitioner. Then obviously I'll take note of all these facts.
my lord, I have come once again, once earlier before this writ petition. What the
Yeah.
authorities have
You
done.
are the owner
by
of a
verbal
wine
order
shop. You
on the
are.
basis
You
of
have the
this-
luxury of coming to the High Court every now and then.
No, my
He
lord,
may not.
my lord, what has happened? My lord, in this case, they have obtained even the signature of the engineer who has prepared the sketch map and the trace map, saying that I did not know for what purpose the shop was open. Your lordship will see one of those complaints. He was the engineer. Then,
All these things, I think, better off ask your junior to go and say before the commission, and put a written statement out there so that tomorrow, when you file a writ petition, if it goes against you, you can very well come before this court. Isn't?
well, the only thing is that our apprehension last time, what has happened? I went along with my son to the office. They come with 50%. Now, these persons who had prepared my trace map, who are witness to my tenancy agreement, they say that I didn't know for what purpose the shop will open or what purpose the
Well,
business
that-
will open.
On the facts of it, I am also saying
Yes.
they have done so.
Yes.
But as of now, you see, if he was asking for an inquiry from this court, I may have refused it.
Yes.
But the fact that the authorities are inquiring, what do I do? Should I stop them?
and
Tell me,
Right,
in his writ petition, how can I?
And the authority under 289,
Well, then I will say, well, instead of going in a crowd and pressurizing the office, let them decide a representative who will represent them, and they will hear. Instead of either the president, secretary, because the president here also has a market complex in the area where I have a shop. The second person also have commercial interest over that area. So what they do, they come with 50%. So since they are representing as a committee, let them decide who will represent before the,
That the
And-
commissioner will decide. The commissioner, if he wants so many people to be seen out there in his office, he wants more of a Netaji type, then he may ask not
No, but
50, 100 people to be there.
that precaution, because we are also apprehensive, my lord, because it has happened last time. They come
Let's
with,
do, but this is not here. Yeah. So best of when the matter is now pending, let it be there, decided out there, and you will be
but,
at your liberty to do so.
so we are agreeable to all the proposal, but only your lot will take care of that, that this 50-60% will not come over the deputy.
I cannot.
And
I
that is
cannot.
where
You-
the
if you
problem
have any
creates.
difficulty, you can always raise it before the. Anyway, let me write it. Mr. B. Kaushik, the learned counsel appearing on behalf of the petitioner. Petitioners, Mr. B.D. Mr. R.R. Gogoi appears on behalf of the respondent numbers 1, 2, and 3. None appears on behalf of the Guwahati Municipal Corporation on call. Mr. B.D. Kaur, the learned senior counsel, represents the respondent number 5. The instant writ petition has been filed challenging the order dated 14/5/2018 passed by the Deputy Commissioner, Kamrup Metropolitan District, whereby the respondent number 5 was allowed to shift his IMFL off licensed premises from Sati Joymoti Nagar, BG Colony, Guwahati 781
No, that he is
781033 to was allowed to shift his IMFL off license shop from Porusozai, Gorolia, Lokra, Guwahati 781034 to Pragjutis Nagar, Bhutanagar, ward number 1 at the rented premises of one of Sri Dipen Das and Sri Dhiraj Das. Full stop. The petitioners herein claim to be residents of Pragjutis Nagar, Bhutanagar, ward number 1, and as such are aggrieved by the order passed by the Deputy Commissioner, Kamrup Metro, to permit the respondent number 5 to shift his IMFL off license shop to their locality. It is the grievance of the petitioner that the inquiry which was conducted by the respondent authorities has been done in a perfunctory manner and without making the in a perfunctory manner. Full stop. The learned counsel for the petitioner further submitted that the persons on the basis of the persons who had the basis of the inquiry which was being carried out was on the basis of a no objection certificate being submitted by 17 persons, of which most of the persons have later on stated that they were fraudulently they were deceived by the respondent number 5, for which they signed the papers, the no objection certificate. Full stop. This court have also taken note of the submission of Mr. B.D. Kaur, the learned counsel appearing on behalf of the petitioner, respondent number 5, senior counsel appearing on behalf of the respondent number 5, who submits that the petitioner, that the filing of the instant petition by the petitioners is not at all bona fide and has been done with vested interest. He submits that all these papers which have been now placed before this court as well as before the authorities are all fraudulently all papers submitted without the knowledge of the persons, without the knowledge of the signatories.
These papers were subsequently submitted under threat and coercion.
All these papers which have been submitted before authorities as well as before this court are papers which have been manufactured out of by way of threat and coercion, and as such, these papers have no meaning in the eyes of law. Mr. R.R. Gogoi, the learned counsel appearing on behalf of the Excise Department, submits that the respondent authorities have taken note of the submissions which have been made, taken note of the submissions which have been made by the petitioner, by the petitioners, as well as the various persons who have signed the NOC, and upon making certain inquiries have submitted a report before the Commissioner of Excise, who is presently dealing with the said aspect. He further submitted that in view of the pendency of the instant writ petition, no further steps have been taken by the Commissioner to decide the said dispute. This court, upon hearing the parties, is of the opinion that as the disputes which are involved out here relates to as the dispute involved in the instant proceedings is presently being dealt with by the Commissioner of Excise, Assam, it would not be in the interest of justice for this court to decide as regards the legality and validity of the order dated 14/5/2018 at this stage. Accordingly, this court is not inclined to interfere with the order dated 14/5/2018. However, this court makes it clear that the Commissioner of Excise shall, on the basis of the submissions by Commissioner of Excise shall, taking into consideration the respective contentions of the parties, shall decide the same, decide on as regards the validity of the order dated 14/5/2018 as per the provisions of law. Mr. Bidiko, the learned senior counsel, has further submitted that there is an apprehension of breach of peace by the members of the petitioners society, taking into account that that almost 50-60 persons come to the office of the commissioner. This court is not inclined to pass any orders in that regard. However, leaves it to the discretion of the Commissioner of Excise to take appropriate steps so that the hearing can be conducted in a more cordial manner. With the above, it is, however, made clear that any party aggrieved by the orders passed by the Commissioner would be at liberty to approach this court.
My lord, we will be permitted to file an objection because that was an expertise order passed, not hearing us.
It is also made clear that both the parties would be at liberty to file their written submissions before the Commissioner of Excise, who shall duly take note of the same and pass a speaking order.
Father, to kindly be pleased to fix the time frame.
No.
Since 2018, my lord, we are for all of it. Let the authorities decide to take a time frame, but otherwise, after Pohak,
Before parting with the record, this court, however, finds it relevant to observe that as the matter has been disposed of, is no longer pending before this court, the Commissioner of Excise would be at liberty to take appropriate action to take an appropriate decision in respect to the impugned order dated 14/5/2018. And as the matter has been pending as the issue has been going on for a long time, it would be in the interest of justice that the Commissioner of Excise disposes of the said proceedings at the earliest and preferably within 3 months.
High level.
In this matter, can I pick up the matter after the
Yes, extension?
My lord, extension is not there, but my lord, there is a provision under section 5, my lord.
5(1)(b).
5(1), yes, yes, 5(1)(b).
So the court has granted you the permission to
No,
do
my
that.
lord, granted not permission for confirmation of the attachment order, my lord. Because under after section 5(1), the next is 5(5), my lord. Under 5(5), the director or any other officer who provisionally attach their property under this subsection 1 shall within a period of 30 days from such attachment file a complaint stating the fact of such attachment before the adjudicating authority. After 5(1), we have to file that complaint before the adjudicating authority. But since that has been stated by the honorable court attachment order itself, my lord, that is not
Understood. But madam, your attachment order was for 108.
then for that one provision is there in section 5(5), my lord, 5(1)(a), my lord. Here, my lord, provided also that for the purpose of computing the period of 180 days, the period during which the proceeding under this section is stayed by the High Court shall be excluded, and further period not exceeding 30 days from the date of an order of vacation of such stay order shall be counted.
Okay.
That
So
is there.
therefore, this period of stay
Yes.
would be excluded.
Yes, my. And additional
But
30
in
days.
case, my case is prior to death, amendment has come. But my case is prior to 2000, if this amendment has come, in FIR has been filed prior to this provision.
No, no.
But according to
Amendment has come when?
2018,
Oh, so this was
Order
done
was-
after that.
And
After
the-
that, my 2020, order was passed in
and
2020.
the original FIR, on the basis of which the proceeding has been initiated, it has been initiated in 2018. On the basis of the attachment order has been passed. The
No,
original
understood. The attachment order is dated what?
That is in subsequent. That is subsequent,
So that.
but on the basis of the FIR, the cause of action matter, cause of action of 2018. So at that time, this is not the schedule offense. That's why another part of the
Understood, but
PC Act was not there.
Huh.
So at that time, under the PMLA schedule offense. That is one part, and the one part of the property, it was not at the relevant time. The PC Act has come as a schedule offense of 1/6/2009, and the property they have sought to attach, my lord, it is of 1997.
Hmm?
It is the property, there are three properties. One of the main property is sale deed, by virtue of which they have admitted for it, my lord. It is of 1997, and the PC Act it has come in 2009.
hey, continue.
Lordship, this is the notification, my amendment, my lord. In our page 7, my lord, Lordship will find section 13 that was inserted, my lord, as a schedule offense.
Then
So my property, which has been trying to attach, my lord, that the Lordship will find their own complaint on notice provisional attachment order, page 48, my lord, of our read petition, my lord. First column, my lord, that the property came to me, my lord, in 1997.
1997.
97.
Then
So there is a PC Act.
so only one property,
Yes,
for-
but the other two remain.
Yes,
other two will remain. That is one part. That is one part. My art. And apart from reason to believe, my lord, that I'd like to place some of the judgment of judgment of. There is one more emphasis has been given. Apart from it, they don't need to intimate that settled proposition, but they have to incorporate in their file
In this incorporated.
or the reason to believe. That reason has to be their matter. His own belief will not do. Occupancy belief. They have to give a proper reason.
So, no. Therefore,
If they
the law as it, in similar provisions as regards the law,
the
you may very well challenge the existence of the reason. Can you see? You may very well challenge the existence of the reasons, but not
Yeah.
the sufficiency. That's also the law.
but in this case, whatever the notice, my humble submission is there is no that reason is not recorded. And the reason
The reasons have been recorded. I've seen it in the file.
that's the reason his own belief, but under what from where he has that belief, that is not there. That is my humble
No,
submission.
it is there.
Yes, ma'am, that day I have.
Because the
So therefore, you are challenging on the existence of the reasons.
and the while
Existence of the reasons on an objective satisfaction.
yes, that objective satisfaction, whether that is there, that I don't know. But from my notice, my humble submission, it does not appear. And the complaint they have filed before the trial court, it also does not appear in that adjudicating offer. Now they have filed the complaint in the trial court. In the complaint also,
Okay.
that is the another requirement as per the recent judgment of Telangana High Court passed by the Honorable Justice Jalmia. That I have brought back.
Where is it?
58. Relying on the key Supreme Court judgment by the paragraph 58 onwards.
But Mr. Bora, understood. But have you mentioned about the filing of the complaint here?
No, Manoj, because it's a subsequent. That's why
So?
so I want to add by filing an additional certificate plot permit. You can bring that.
Because that will be completely a separate ground
Yes,
as to whether it is
Because
accompanied. The reasons are accompanied.
Yes, Malad, that
With
is
the
in the
complaint?
notice, that is in the notice, Malad, notice itself, Malad, provisional attachment order, Malad.
No, regarding
Because
No, no.
complaint.
No,
complaint, Malad,
what he is saying, you say, after this,
Yes.
you have filed some complaint
yes, Malad.
under 5.5.
Yes.
Now, in the 5.5
Not
complaint,
like that, under section 45.
Huh?
45 before that, special judgment.
you have not filed any complaint? To me?
This is under section 44, 45. We have filed before the trial court.
This is 5.5, got to be correct, man. Complaint is 5.5, madam. This is
The file. Okay, sir.
it is under 5.5, madam.
It's my, I'm giving the 5.
The trial court order also, madam.
Show me, let's see where it is required that the reasons is to be given. The director or any person who provisionally attaches any property
Right.
under subsection 1 shall within a period of 30 days from such attachment file a complaint stating the facts of such attachment before the adjudicating. No, where is it mentioned that it should be, except this judgment of Delhi High Court, which says so? The act does not say that the complaint which is to be filed shall only state the facts of such attachment before the adjudicating authority.
I think the 5-1 will follow in the whole.
I-1 says where the director or any officer not below the rank of so and so has reasons to believe, the reasons of for which belief is to be recorded in writing, on the basis of the material in his possession, that any person is in possession of any proceeds of the client so and so such as concerned, he may by order in writing provisionally attach such property for a period not exceeding 180 days from the date of the order in such manner as may, provided that no order of attachment shall be made unless in relation to a schedule offence a report has been forwarded or a complaint has been filed by a person authorized to investigate the case mentioned in it before a magistrate. Then that not concerning anything contained in the first may be assessed on the if belief that such protection. how does the Delhi High Court or the Telangana High Court come to an opinion that they have to, that the AI has to accompany the reader?
Yes, that I have taken.
Because this doesn't
yes.
show so. The act doesn't say so.
That's not.
Because the here only, if you see
Yes,
this
but
judgment also, here also it says a division bench of the Delhi High Court held that the reason to believe at every stage must be noted down by the officer in the file.
Yes.
While the reason to believe recorded at the stage of passing of the order of attachment under AR may not be communicated forthwith
Yes.
to the person adversely affected thereby at that stage. The reason is recorded and has to have to accompany the complaint filed by such officer within 30 days before the adjudicating authority. So their complaint, they may forward the file
Yes,
where the
ma'am.
reasons will be recorded.
Complaint
But-
that is probably 5-5, my lord.
Yes,
Or-
5-5.
five.
Their complaint, which is to be submitted, they will place it before the adjudicating
So
authority.
that here, my lord, in that complaint also this reason is not. That is my.
But that
That is that's what I like doing it on record. Not with permit.
No, the reasons.
But otherwise, it will be difficult to
My lord-
revert for us.
Because
Yes.
here the reasons, it doesn't say that it has to have the reasons. I don't know under what basis the Delhi High Court has. You have the Delhi High Court judgment?
No, man.
Because this is the Delhi High
Yes,
Court judgment,
based
not the
on the
Supreme
daily
Court.
alert, then the subsequently there are Supreme Court judgment also is mentioned. So let the matter come up after the notification.
As I referred to you, no, 62.
Yes, 62
S.
days.
S. Narayanappa and Shivnath Singh.
That's the
Yeah,
basic
this-
first case, my lord.
Yeah, this is the basis on which it
Yes,
is being played.
subsequently, there are other cases also. That is in 61.
There is another one,
Calcutta Discount
Ayurved Award or something. That is a matter pertaining to another act.
It can be my lord, in Modern Lal case that also is decided, but it is in respect to region to be Modern Lal case. My lord. Supreme Court has decided my lord, regarding the region to be that is on the basis of documents and on
Yeah, that is okay. That is what.
Yes.
It has to be subjectively taking into account and having an objective satisfaction on the basis of the material.
That objective
And my lord-
satisfaction, where from he has brought in.
Objective satisfaction will be on the basis of the law.
and section 5 does not say my lord, and my
We'll
lord,
have it on 18th.
18.
List the
And
matter
another-
again on 18th. You don't require the entire file. You can take the file, whatever may be. You just give her a copy of the reasons,
Photocopy of the
Huh?
photocopy.
photocopy of the reasons to believe.
But another, it is there after section 44, 45, my lord, they have filed a complaint, my lord, under PFLA Act. But there is a no stay from the High Court, but taking the advantage of this case, my lord, they are taking, my lord, adjournment in that case, my lord, that may be observed.
No, we are not taking
My
money.
lord,
Have you
can we
changed
see?
the order sheet?
Yes, but order is
Court is asking for the order. We are not asking for any.
kindly see, my lord.
We have not filed any single adjournment. That is the order of the court.
That has not been proceeded.
We can always proceed with that.
Oh, but
There is no bar at all.
it is
Okay, list the matter on 19-1-2014, 24 for further hearing. It is, however, mentioned here that It is, however, observe that the pendency of the instant writ petition shall not preclude the which court,
That is
Special
my
judge,
special
madam.
judge.
special judge,
What?
Assam.
Assam.
Assam,
Yes.
to proceed with the special bracket PMLA bracket case number 1/2020.
Because after the filing of the complaint,
Hmm.
he also can attach. He also can attach. There is no bar. But they have not placed it. That is proceeding may go, my lord, or remain. But there is a still the court can attach people under giving a reason.
Because Mr. Bora, only thing this court I find it difficult. This judgment is there of the Delhi High Court or the Telangana High Court. These are only persuasive,
Yes.
taking into account. But if you see those judgment of Satyanarayana, Shivnath Singh, and all these things, and even in a very recent 2023 also, it mentioned very clearly that the reasons to be recorded is not to be furnished. Now, if that be so, and it is also mentioned that it has to be on a objective satisfaction. The only challenge which you can make out here is as regards the existence of the reasons and not the sufficiency of the reasons.
Or
Now-
initial,
If the act does not say that the reasons are to accompany the complaint,
that I understand. Because of these
how
judgments.
how did the
That's what I'm-
the Delhi High Court just find out they're more particular because the judgment of the Telangana High Court bases itself only on the Delhi High Court judgment.
Yes.
You have a copy of the judgment, the Telangana High Court judgment?
Yes.
So you can give it. Good, really.
Let it be in the file, ma'am.
You want it?
Yes, madam.
Take a photocopy and give
Yes,
it to him.
Problem.
Yes.
Yesterday, Lordship pointed out that the status quo which was granted, Lordship, till returnable date, and thereafter it was. I have checked Lordship that it is correct. It was not accepted. But my submission, this Lordship, your Lordship needs to come to the order dated 23rd August 13, page 23.
But here you are asking for violation of the contempt of
There I
2015.
committed mistake.
Then-
I had not.
So nothing remains here.
No, Lordship.
No, nothing remains because here you are asking, you kindly come to paragraph number. Why you are asking paragraph 18? You say that in utter violation of the order dated demand passed by this honorable court, so and so willfully and intentionally on demand started thinking on 18/4.
Yes.
If it is on 18/4, there was no interim order. There is no status quo order as on that date.
No,
And that is the
status quo order was
violation why
there.
you asked for.
Status quo order was there, but in the earlier date.
But that is here you are asking for
Your
violation of.
Lordship is correct. I committed a mistake. I may be allowed to file amendment petition by tomorrow.
No, nothing. This you want to file that is the amendment doesn't remain out here for this. There was no order to that.
Just your Lordship will please to peruse that the earlier order.
Okay, now let us come to the main requisition. This goes.
Lordship.
Let us come to the other two. What requisition?
Those are not for hearing.
Huh?
Writ petitions are not fit for hearing.
No. All matters are taken up for plea.
The matter is fit for order today for contempt petition. I am ready, I can do.
Yes, please argue.
Yes.
Let us first argue eight.
So just Lordship.
4765.
Lordship, may please to peruse the earlier order in
Hmm.
contempt petition.
Hmm.
Page 23.
Hmm.
That order is still in.
Hmm.
Annexure 5, page 23, order dated.
That is 23/8/2023.
Yes.
Which, what does it
No.
say?
13.
As regards the interim prayer, it
13.
is submitted, the petitioner has already been evicted from the land in question, and the structure standing thereon has also been demolished. However, status quo as on today in respect to the land in question shall be maintained.
Maintain.
Meaning thereby what?
So they did not maintain lordship. They constructed the lordship houses, boundary walls. This order is still in force law. Because, and the second writ petition was only to enforce this order dated 23rd August 2013. Second writ petition 8481 is only prayer is for enforcing this order of 2013 law.
Let us see now. Here you are asking why you should not be restored back to the possession. This writ petition 4765 of 2013.
Yes.
You are the owner of the land.
I am the right
You are the right of the land
under the tenancy act.
under the tenancy. Now you have been evicted.
Yes.
By these persons, by the private response.
Government officials as well as private. Mainly government of circle officer, OC Gorchok PS, lordship without issuing any notice, lordship,
How did the government officers evict you?
lordship,
How did the government officers evict you?
lordship on. I have annexed that order along with the contempt. Your lordship will please to peruse the earlier writ petition of 2013.
Yes.
Lordship will please to come to page 16, annexure 1 lord. This is the Kita copy lordship which shows that it was a Pata land lordship and old new tag number total area was 12 bighas 4 kata 9 letters. Landlord name are shown Sukra Kathari Bhatti Kathari minor Mata Siddhi periodic Kiras Pata name of the Rayat Jagdish Gupta. That is the present petitioner. Agricultural land lordship Khatian number 529. In vernacular certified copy also have file just below that.
And
Then lordship may come to page 18. Name of the page 18 annexure to lordship. Name of the Rayat his father Jagdish Gupta. Lordship Khatian number 528. Old and new tag number has been given lordship. Area of the Raiti land is lordship 1 bigha 4 kata 9.
this is a government land.
No, Patta land.
Where is the patta number?
Patta number is mentioned lordship.
Patta number is what?
Patta number is mentioned.
Where?
Yes, sir. Lordship may come to
Annexure 1.
annexure 1 lordship here Patta number periodic era. Number has not been given. But status of the land is given periodic era. Lordship. Khatian number has been given, tag number has been given.
Okay, then
Then lordship will come to page 19. Here Patta number is given. Page 19 lordship regarding payment of the six pura rights to the landlord, type of riot, virtue of possession, by virtue of possession. Name
here,
of the
here patta number is where?
pattern number, KP pattern number, lordship, the
Not
second column
mentioned.
from the right side, page 19, KP pattern number 254.
Huh?
Page 19, Lordship, from the right side, second column, patta number KP 254.
Patta number.
Yeah.
254.
Then Lordship may come to page 22, Annexure 3. This is the copy of the Jamamandi draft, Jamamandi Lordship. Here the fact is this Lordship, earlier it was a government land. And it was settled by the government Lordship in favor of the landlord. After conversion from the government land to patta land, that endorsement your Lordship will find at the bottom, page 22. Application number TR 1089 of the year 1961. ASO dated 30th 462 and 547. Number Chalan dated 24/562, premium paid, having serial dark number so and so for the land measuring 21 biga 2 katha for allocated in new patta of the year 1369 as per Assamese calendar. I had also-
How do you have any relevance with this patta? Because the earlier patta you were mentioning about this
during settlement operation, Lordship, patta number, dark number change.
so this changed from 283, it became 254.
Yes, Lord.
Huh?
Yes. It become Lordship as per Annexure 3, phase 3 Lordship.
Hmm.
The patta number at that time was 283 on the right side left. Extreme left Lordship, patta number 283. Old and new dark number has been given Lord. Dark number here it is relevant is Lordship 284. So 284, government is saying that this dark number 284 is a government. But this Lordship, when the land was allotted to the landlord Lordship, entire land was become the patta landlord. Then Lordship may come to page 24. Page 24, Lordship, here the riot that the petitioner, he has constructed houses, fortress, boundary walls, and cultivating the land, Lordship.
Hmm.
This is the municipal tax receipt. Then page 25, Lordship, with the electricity document, Your Honor, standing in the name of the petitioner, Lordship. Then Lordship may come to page 26 and Annexure 6.
This is your application.
This is my application under section 23 of the Tenancy Act 1971 for acquisition of the ownership right lot. So here also Lordship, the Khatiyar number has been given, patta number is also given, tag number is 284, area of the land is 1 biga 3 katha.
Then
Then Lordship may come to page 29, Lordship, Annexure 9. This is the letter by the Deputy Secretary to the Government of Assam Revenue and DM Management Lordship to Deputy Commissioner Kamrup Metro Lordship. With reference to subject and cited above, I am directed to enclose where is a petition dated 18/3/13 received from Sri Jagdish Gupta along with his enclosure and request you kindly to send the case records in the original the government at an early date. But this order was never complied with by the office of the Deputy Commissioner Lord. Then Lordship. So these are the facts, Lordship. Pleaded case of the petitioner Lord. And Lordship, when I was well versed that in under if a person is having a tenancy right, cannot be evicted forcibly and illegally, Lordship, at the behest of the private respondent. Because Lordship, the private respondent, Nirmal Kumar Sharma's land is situated just on the backside of the land of the petitioner, but he had no access to his plot, no connecting road. So that's why in correlation with the circle officer and the OC, Gochok PS Lordship, as the conspiracy and in the name of and evicted the petitioner forcibly illegally without serving any notice under any other provision of law. Neither it was a rule at 2 or 18(3). Notice cannot be issued because it was not a government land. And till that it is not a government land. It is a patta land.
Who was in possession of this land?
Petitioner was before eviction lordship.
Prior to
Petitioner was
that?
in possession since more than last 50 years, Lord.
Understood. But since when?
Since when lordship I have stated?
Huh? From the Khotiani, it reveals that it has been for the last 12 years.
More than 12 from the date of issuing of the Khatian. So 12 of the Khatians were issued lordship in the page 16 shows lordship. This revenue record is of 1957-64, where position has been given on 12 years.
When was the Khatian issued?
Khatian was issued lordship. The date has not been given. I have also annexed the vernacular. But certified, it is mentioned on the top of the Khatian lordship that it is for the year 1957-64, page 60, at the top right side.
Khotian,
Khatian.
copy of the draft variety Khotian.
Yes.
Beltola Moser, Beltola Gaon, variety Khotian. Huh?
Certainly, please look at page 18, where position has been shown. 12 years, which was a second Khatian lordship.
So 12 years, who have been residing? You.
Yes,
And what are you doing?
I'm agriculture.
What is your age?
At that time, lordship, the age was 60,
0.
64.
Because you are 63 years as on 2013.
No.
Yes. That is your affidavit.
My father had taken the position.
Have you mentioned it?
Yes, yes.
Where?
I have
Your
mentioned.
father had mentioned the position.
Yes, yes. I have mentioned in my additional affidavit in.
No. Here. Where have you mentioned that the petition I have been? Just see.
It is clearly not mentioned in the petition, but it is mentioned in the affidavit in.
Your father was.
My father,
No mention to the. When did you file your additional affidavit?
I filed it lordship on 7/5/14. 7/5/14.
Immediately after 10/2/2014.
Yes. If you highlight it.
So the only question arises as to whether it was a patta land or not.
No, it wasn't. There is no dispute to
There
that.
is a dispute. Clearly, they are disputing. It is a government land which they are saying.
Lordship, in their affidavit innovation, they have just stated no revenue documents have been annexed, Lordship, to prove that.
No, the first document which you are referring to doesn't have a patta number. That is why I asked you.
Revenue records, Lordship, what the.
No, what
person
it is,
is-
no, no, means,
But the second document.
first
shows
of all, it doesn't have a patta number.
None.
The second one has a patta number given out there. And the third, how do you correlate the third with the first, the second?
Lordship, there
How do
are,
you correlate the third
there are
document with the
many
first?
Khatiyans, Lordship, which does not show, do not show any pattern.
No,
Khatiyan number
if
shows
it is
area
not
of land,
so, then
landowner's name.
we'll decide in that particular case. But in this case, we are concerned that show me that it is not a government land.
No.
Here they categorically say that tag number 524 is a government land. It's a go back.
No.
So under
Here
such,
disputed land, tag is 284, Lordship.
we are concerned with 254.
284. 284, Lordship.
The 284.
Yes,
Yes, tag number 284
yes,
of 524 new is a government land.
yes. I have
Show
shown,
me that it is not
I
a
have
government.
shown the Jamabandi, Lordship. That is a
Government of what?
government record
That is
by
not-
which the land was converted, allotted to the original landlord, Lordship. That I have already placed before your Lordship. That document.
No, this document does not show to that effect. This is in respect to some other patta number,
No,
283.
Lord. Yeah.
How do you correlate 283 with with 254?
Lordship.
How do
disputed-
you correlate 283 with this 254 patta number?
I have stated in my red petition that during
That is, then you
The
better
during
off
settlement
go before the
operation.
trial court and show all these things.
Lordship.
But this is not the court. If you are to show, you have to show it clearly. How do you correlate to the document number 3 with the document number 2? They are the government is categorically saying that 254 or 284 dark 524 is a government dark. and therefore they have evicted you.
But
Isn't
lordship,
it?
when the petitioner has pleaded that it is a patna land lordship, the burden lies upon the government to prove that it is not a
The
patna
burden
land.
is you.
Yes.
Burden is not him. Burden is you. You are before this court.
Lordship may please again.
You may say tomorrow that the sun rises in the west. Are they to prove that no, it rises in the east?
Lordship, for the sake of argument, assuming
Hmm.
lordship that it is a government land,
Hmm.
whether I was not entitled to get any notice
Why?
under rule 18.3.
No, you come under 18.2.
No, this is not a roadside reserve land.
Not required. Any land. Nowadays,
No.
any land.
18,
You see what they have done, I'm telling you. Nobody has put up the challenge. 18.3 now has become useless in view of the amendment which has been made in the year 1992 to 18.2.
Lordship, but by rule 18.3A, 15 days time.
Mr.
notice
Counsel,
should be
kindly
given
read
mandatory.
18.2. Kindly read 18.2.
No, no, Lordship.
No,
Rule
if you are saying so, that is why I'm saying
18.3, Lordship.
18.3 has become redundant in view of 18.2. Kindly see this, why I'm saying so. Earlier, prior to 1992, it was only for three types of lands. Roadside reservation, what you call grazing
Land,
lands,
land.
and certain other specifically reserved lands. Now, any land where you don't have a right of proprietorship, you don't have a right of settlement holder, you can be thrown out. That is why I'm saying after 1992, after that, what is that, Radha Kishore or what was that? Radha Kanun judgment, they amended this. And thereby, 18.3 has become useless. Kindly see that provision 18.2.
Settlement.
And give him a new book. No, no. The only thing is, if you have a bona fide claim, that is the only way out. You see, kindly see here. If you read, where such person has entered into the possession of government caste land or wasteland. Now, amendment has been brought. Government caste land or wasteland or estate which no person has acquired right of proprietor, landholder, or settlement holder, or any. Now, till here, this has been brought in by the 1992 amendment, 1997 land. That has been previously now, and or any land that has been previously reserved. This was the earlier thing. Reserved for road or roadside or for grazing or village cattle or other public purpose, or has entered into the possession of land from which he has been excluded by general or special order. When further, there is no bona fide claim or right involved, he may be ejected or fit without it. So therefore, 18.3 becomes useless in view of this amendment.
But 18.3A provide that 15 days.
Understood,
notice
but
must
if
be
you are
read.
not, if you don't have a right of
No,
proprietorship
but I am
of the
having
land,
the right, Lordship. I am not an encroacher. I was never in unauthorized occupation of any government land. I am not the encroacher. So provisions of the rule 18 or 18.2 or 3 will not apply in my case, Lordship. Because Lordship may be pleased to peruse by affidavit reply the government has. Lordship will come to page.
no, Mr. Roy, unless you show me the link between document number 3 and 2.
Yes, Lordship may come to page 23 and Annex 3.
Yes, that is just in front of me.
The vernacular Jamamandi, Lordship.
Yes, that is
Your
dag
seat,
number,
Lordship, tag number,
pata number 283.
yes, pata number,
283.
Lordship, 283, Lordship.
And
There
and
the
what
tag-
are the old dogs?
Tag or
Old
number
dogs were given, and new dog is 285,
284 is there.
284, and 708
284 is also
is given. That is pata number 283.
283, yes.
But your document number 2 is a pata number 254.
Well, during settlement, I have made amendments in the writ petition that during settlement operation, the patta and the number was changed to this and that lot. That amendment is very much there, which has
Le-
not been denied in their affidavit.
No,
of
they
petition.
categorically say that to Dag number 254, 284 and Pata number new 524 is the government land. That they are
Government has-
categorically
but-
saying.
But they have not produced any record, they have not annexed any document with their affidavit. Mere making amendments in the air will do lots of.
But unless
to
you show
sustain
this
the
collect,
amendment.
no, and you have to show the connection.
Yeah, I have lot.
You have merely making statement would not do. You have to show the connection.
Same thing will apply in case of respondent, official respondent lot. Mere making amendment in the petition that it is a government land will not do. They must annex the revenue record. Why they have not annexed lordship? What is, or lordship is pleased to call for the record? How a person will be evicted from a patta land without issuing any notice, demolishing the house's lordship in a democratic country? Lordship is pleased to come to page 4, para 4 of my writ petition. The person was a long position, more than 50 years lordship. He cannot be evicted. Long position is a
No, long position has no value.
division में judgment is there.
Division bench, let it be. Then I dismiss you, go to the division bench, will help you.
And your lordship
Uh,
is pleased to dismiss what I
284,
can. But
This has no patta. Next up.
lordship will be pleased to come to my affidavit in reply.
You see kindly this document. 284, 257.
Mandal report is there, circle officer report is there, that it is a patal.
Now, Mr. Roy, kindly see another thing. Page 17, read it again with page 23.
Page 17.
Page 17.
Yes,
This
Lord.
dag number 284
Yes.
was earlier dag number 277.
Yes, Lord.
Now here if you see in page 23, the old dag, there is no 277.
New Dagage Lordship 284
Aha.
and Purani 277.
275.
No, 277.
Purani is 275. Kindly see.
My page 17, Lord.
No. Page 17 is 284 is 277.
Yes,
Kindly come to page 23.
20. Yes, page 20.
Now you don't find Purani 277.
Because Lordship during settlement operation, the
Tag number will
and patta
change.
number frequently changes. Until and
Understood.
unless the
So,
final
so,
draft-
so the new patta number after the settlement will be the new one. So that is 284. And the corresponding dag,
patta, no patta. 284 is the dag.
understood, that is what? Kindly see 284 at page 23.
Yes, 284.
And the corresponding one, the Purana one, is 275.
Here also it is 275.
But here it is 277. This
No.
document at page number 1, the annexure 1.
No, Lordship may be pleased to come to middle where 284 dag area has been given as 12 bigas. Lord.
And here,
Tag number has been shown 275.
yes. And here it is 277. This document at page 1, and the 17.
Yes, Lordship, because that was a draft chitha. To the draft it, our lordship frequently drafts are patas are changed until the final Jamamandi is prepared law. In, from here there is a remark at the bottom, page 23, 1960-61 সনদ ইয়া নম্বর ইমান দরখাস্ত দিয়া এসো 30/62 ইমান নম্বর প্রিমিয়াম আদায় দি ইমান নম্বর অঙ্ক 21 বিঘা 2 কাঠা 4 লেতা জমি নতুন পাট্টা ভুক্ত কর। So in this is government document, certified copy of the Jama. What more is required to prove?
Yes, who is paying for the government? More particularly, who is paying for the additional deputy commissioner Kamrup Metro?
I'm paying.
Have you seen the affidavit?
Yes,
What does it say?
makes it very clear. There's the
Very.
go but the dark
Now,
numbers.
how do we know that it is Gobat?
So in the for that matter, even though the annexes are not here, the record would prove if at all court wants to have a review.
That
the
is what
record.
I will. Now, kindly come to paragraph 4.
Yes, I am gone through. Yes, 4. Read petition. The opponent begs to
As
state that
per Rayati Khutian number
5 to 8 in KP number 2
number 254,
Dark
dark number
277
277,
all.
all 281, there is no mention Moza and Bilek.
Yes,
It is only in the draft
Draft
letter
it.
of 1957-64 that there is a mention of state land as within Belpola, Moza and Bilek. Accordingly, land measuring 79.49 are covered by dark number 284 of the 299.
all.
Now let's come to 284
Hmm.
and 299. How much it will be? Total 299, 284, 299. Where do you get this 299 from?
In fact, in
You see, another thing, kindly come to another document which I am showing it to you. Here, there is that document. Yes, page 17 of the writ petition.
First connection.
This document shows the name of these two persons were struck off and shown as Sarkar.
Tupurak, yes.
Okay.
Yes, that thing we have reflected in the affidavit also, that is Tupura Kachari and Sri Batiram Kacharis were recorded as Patadar, but as per remark column, the name of both the Patadars were cancelled from the Khatiyan number 5.
No, there is no patel. Where do you get the remark column? This is not the remark column. The remark column is absolutely on the left hand side, right, extreme right hand side, 524 number Kotian.
Khatiyan Mote.
Okay.
Rest, yeah.
Now kindly come here. Pottadaro Nam, Pitar Nam.
Hmm.
You see, both their name has been given. Then you make it Sarkar.
Short, down below.
Now, in your affidavit, you say, categorically say, has been recorded, but as per the remark column, the name of both the Patadas were cancelled from the Khatiyan. However, there is no order in this regard in the state Khatiyan.
Yes.
That so-and-so mentioned at Tolotia Raya in the Chita of Iman, and that he has been occupying Iman. According to from 1947, 12 years prior to that will be 1946, which means that he has been cultivating since 1945. So this means that Sri Jagdev was born in 19 Iman. But given the details of where there is no familiarity with Patna, but given the details of the land record, further 284 4 is Bobat, government accordingly as per the parliament document. You produce the Jamabandi in respect, Chita and Jamabandi in respect of dark number 284 old and 524 new.
In that 299 in all probabilities, that is the SMS 277 must have been written as
You see,
299. But there is
no, why I'm saying it?
Yes.
Is page 17.
Hmm.
This court has great doubt as to how this document was made because of the fact.
Hmm.
If you want to make it Sarkar, either the land has to be acquired by the government.
Yes.
Because if it's a patta land, it has to be acquired. A person would not lose his right over the land unless it has been taken over by the government.
for non-payment of the revenue.
Whatever non-payment of revenue also you have to cancel the
Okay.
patta.
There has to be consulted.
If
There
it is
will be
non-payment of
renewal
revenue.
of-
But
Or
for that
may-
matter, the record column would have the.
absolutely.
Yes.
So this court has great doubts on this veracity of this particular document at page 17.
Hmm.
How can you just type up their name and put it as Sarkar unless there is any mention?
There's no mention.
I applied for the certified copy of that annexed that document lot. Nothing is available in the official.
So therefore it was never made Sarkar, I suppose. Or this document does not exist.
Maybe.
Something must be there.
That's why they have not annexed.
No. They will have the Jamabandi of 520.
No, not annexed to the affidavit.
They will annex. They will bring it. Don't worry.
No.
But I have serious doubt, Mr. Borwa.
Yes, yes.
This particular document, means normally when it is made Sarkar, is either the acquisition have taken place, the government has taken over the land, or the settlement has been cancelled in a manner provided in the law, or he gets the ownership right by way of a Khatiyan.
Khatiyan.
But then his name would have been there as a Patadar. But how is this thing will happen?
His claim has already been denied because he says that he has been in possession. But from that records and going by the affidavit that he has filed, we can make out that he has been claiming to be in possession prior to the date when he has been.
That is another thing. That is another aspect which you are not. With Mr. Roy, you cannot deal with those silly things. For him to be dealt with, has to be dealt with in this manner.
Document.
So 524 and 284.
Mm.
Huh? Okay. And also give a report as regards the veracity of this page 17.
Yeah.
Huh? Get the because this is a very,
Yeah.
it shocks this court. How is it? How can it be made Sarkar?
Okay.
Unless there has been a the auction proceeding for cancellation because of the whatever may.
But
You see, if there is a non-payment, also, you can go for auction.
option here.
And if you see there also, after conducting the auction sale also, whatever amount we made, we have to pay to them, the patak. Because
one-
he is the owner of the land.
Hmm.
So how can you make it Sarkar in this way? Or whether this document actually exists or
That's it. The old Sita reflects those names. In fact, 57, 64.
because you see,
This is the
inserting
old
names
record.
here and there is
Hmm.
not a big deal.
Hmm.
It's not a big deal. It is a very simple thing. You will catch hold of that mandal at that point of time, you will do that. It's not such a big.
I'm afraid those mandals are no longer. Because
This is how it is being done. Anyway,
Lordship had annexed 10, page 30. I had filed a RTI application for obtaining that document, but the Lordship has just now pointed out.
which
They
one?
failed to page 30, Lord.
The copy of the draft sheet of dark number 284 old, 524 new.
They failed to supply me.
The particulars remarked are by the concerned demand.
There is no such document in the office of the.
No, they cannot file an affidavit without knowing. First of all, let us start the morning with the dismissal of the contempt.
No, Lordship may be pleased to consider.
I am not.
I'll take only
No,
5 minutes.
no. The instant contempt application has been filed violating, alleging willful violation to the order dated 2/3/2015 passed in WPC number 848 oblique
Yes, Lordship, I want to
2015
point
by
out,
this
There
court.
was a writ appeal, Lordship. Writ appeal also passed the status court.
Where?
Yes.
In this case?
Yes.
After it?
Yes.
But that is not the case. Yeah. You are not asking for violation of that order.
Yes, that is.
Then,
So that's why I may be allowed to amend the.
no.
Lordship, in contempt proceeding, our duty is just to assist the court.
You have
is-
assisted enough. This court have duly taken note of the order dated 2/3/2015 passed by this court in WPC number 48848 oblique 2015. From a perusal of the said order, it reveals that there was a direction that the notice of motion was issued making it returnable on 1/4/2015. And further, there was a direction that status quo as on that date, as on 2/3/2015, be maintained in respect to the land in question until the next date fixed. The record further reveals that on 1/4/2015, the said status quo order was not extended.
Matter did not reach.
It says list the matter after Bihu vacation. Order is there.
But actually, for one for Lordship, I have.
Mr. Counsel, I am saying that don't disturb you. I'm saying I would not say otherwise. If you want, you can have a look at. But this is subject to cost of 10,000. Yes. On 1/4 list after Bihu vacation. 10,000 upon Mr. S.P. Roy. কি দেখিলে last line টো? Not ex- This court have also perused the contempt application, and more particularly at paragraph number 18, it has been alleged that the violation of the order dated 2/3/2015 was on 18/4/2015, when the contemptor number 1 had started digging up earth and piling boulders and gathered huge construction materials over the scheduled land of the petition. So, taking into account that there was no status quo order with effect from 1/4/2015, the allegations on the basis of which the instant contempt application has been filed and taking into account that there was no order of status quo beyond 1/4/2015, and the allegations made in the instant contempt application is post 1/4/2015. The instant contempt application is misconceived, for which the same stands closed.
My submission may be recorded that earlier state petition number 476546, there was a status quo. That I had submitted.
This is for your to submit in epilogue. Go and file. Click on main receipt. WPC number 4765 of 2013. The instant writ petition has been filed by the petitioner being aggrieved by the actions of the respondent authorities in evicting the petitioner from the land as described in the schedule to the writ petition, and for a further direction that the said that occupancy rights in respect to the same land be conferred upon the petitioner. No, occupancy right. Ownership rights.
Acquisition of order.
Ownership rights may be conferred upon the petitioner in terms with the provisions of the Assam Temporarily Settled Area Tenancy Act 1971. This court, upon perusal of the writ petition, finds it relevant to observe that Annexure 1 to the writ petition is a copy of a draft chitta. In the draft chitta, surprisingly, the names of the patadas have been struck off, and the name of the and it has been shown to have been shown that it has now become government land. The respondent authorities are directed to apprise this court on the next occasion, on the next date, as to why, as to how the said names were struck off and the land has been shown as government land. Further to that, this court have also taken note of the affidavit in opposition filed by the respondent number 4, wherein it has been categorically mentioned that the land measuring 79.49 R covered by dark number 284/299 old /524 new of Betpuchi village within Beltola Moja is a government land and go but. The respondents, though, have mentioned all this, the said aspect in the affidavit, but there has been no documents enclosed evidencing the said statement. It is the opinion of this court that the record of rights in respect of Dag number 284/299 old/524 new of Betkuchi village within Beltola Moja would be required to be produced for a proper adjudication of the petition. Accordingly, the respondent number 4 is directed to produce before this court on the next returnable date the chitta pertaining to Dag number 284 of the chitta as well as the Jamabandi in respect of Dag number 284/299 old/524 new of Betkuchi village within Beltola Moja.
Lordship cadastral map also, because there is no go bar in the cadastral. Incorrect government. Till
No, it
this
will
goes-
be, they categorically say that it is recorded out there as Gopa. So if it is not recorded out there, then we'll consider. List the matter again on 19th of January 2024. for further
19 Lordship, I not be able.
Can it be sometime later, because again the Bihu vacations, maybe
22nd of January.
20,
Now what is this 848?
same for enforcement of the status quo order passed in 2030. And that was the main. Very clear, yes.
What remains in this?
Sure.
Nothing. We close it. Your main is that you already have a status quo.
Together,
Why?
there are certain
There's nothing else.
additional documents.
You see, tomorrow you win that case, you'll get the land. You won't get the land with this.
But on 22nd Lordship, first credit petition should be dictated along with it. Your Lordship can be disposed of, but it should, because some annexures are there, which are not available in.
No,
WPT.
all these annexures are there. I've seen it. Now let the affidavit
Photograph.
be there. Anyways, let us see. They made some road.
That order was challenged in the writ petition, and a status quo order was passed by the applicant. By violating the status quo order passed in first writ petition, it is still in court.
This status quo order is also, Mr. With due respect, it has been all along stated by the Supreme Court that the status quo order has to be specific. What type of
It is a
status quo order
specific-
has
that
been passed?
status quo will be maintained in respect of the land.
Where?
Yes, Lord.
Show me.
Yes, yes.
Respect to the land for what? Possession? Proprietorship? Ownership? Which one?
Because the petitioner was evicted, Lordship.
So what
So
is
how
the
can you
status quo mean?
determine
So does this land remain all along like this? There might be things that why is this court?
Order is status quo as on today in respect of the land.
Huh?
The question shall be met. That is the order. That is
We vacate
23,
that order.
23.
We vacate that order. You see, however, status quo as on today in respect to the land in Selva. What is this type of order? After the land has been evicted, anything happens, it will be subject to the outcome of the writ petition. There's no meaning with that status quo order. Any right which happen will be subject to outcome. Tomorrow, if they build the house also, or they should have made it more clear that don't make any construction. Making a status quo like this, on one hand, you say that the interim order has been paid as the petitioner has been evicted, so remove it. So we are not saying anything.
Majority
And
of
then on last line, however, status quo as on today we maintain. What is it? चलो कौन बचते के अकेले काम all this problem arises. Mr. Roy, only thing out here is as to whether you were rightly or wrongly evicted. We do one thing. That status quo order, which is there in that earlier petition, we make it very clear out there that there shall be no transfer, any further transfer of any type.
Transfer and construct, further transfer and further. Because they are let out to the, actually land has been given to a private Marwadi businessman, some Sharma. Lord,
Who
who
is
has
paying
the-
for that Sharma?
Lordship,
Who is
is a
appearing?
party.
Huh?
It's a party.
Who is appearing?
Nirmal Kumar
Mr.
Rao.
Ghosh was appearing, na?
He appears only in the concept.
Or he is no longer there. And here service has been affected.
He has filed an IA for his implement.
Then who is appearing there?
That IA is still pending. That IA is Lordship. IA number is
AK
Lordship.
Das, J.
Triple
Bhuya,
one
K. Kolika, P. Sinha. And that IA has not been allowed.
No, pending.
Then
IA number 111.
this is in the other year.
Yes. IA 11115 has been filed in WPC number 47.
And there is no one. IA 111/2015 on the copy. When the matter was taken up, there was no person, there was no counsel representing the applicant to move the instant application. To list the matter again on 22nd of January 2024. It is made clear that if the applicant is not represented on the next day, appropriate order shall follow. Baki kita with detail. And what is this 2782?
One Dr. Kaliram Das, he filed an application for his implement, and he was treated.
There is an existing Bhopal and the same people.
278 Lordship 1, Dr. Kali Das Sharma filed an petition lot 2782, saying therein for eviction of the sum of the input, whereas the present petitioner is not a part. Sorry, where Lordship present petitioner is respondent number.
or 22nd. 23rd, Mr. Purva. Okay.
Obliged.
The top of the
Please, Lord. I have filed the affidavit bringing the record of that rule.
Where is the respondent number 7? Nobody is representing you.
I have heard that Mr. Ahmed is in England,
England,
my lord.
what happened? In the school weather?
Her his daughter, my lord, getting admitted in MBBS court, medical court at England, my lord.
I think then it will be better. Just keep this matter for another few days.
Otherwise, the other is working, my lord.
Yes,
Lordship, Mr. J. Ahmed is out of India. And the
it has been
Yeah.
pending for such a long time.
last,
As the order is going to be prejudicial to him.
My
When is he coming?
he'll
Or has
come
he
in,
settled down?
after 4 days. After 4 days.
4 days. We'll have it on 30th of January, 30.
Well.
It's the matter, taking into account that Mr. J. Ahmed, the learned counsel appearing on behalf of the respondent number 7, is not in station. The matter stands adjourned. We listed again on 31/2023, 24 for further hearing.
That my lord, affidavit.
You have brought that rule, na?
Well.
What are you challenging? Board of Revenue.
Revenue.
Challenging the order dated 7/4.
14.
Is that Yes,
Yes, Mr.
who is appearing for the government? Yes.
Basically, only on one ground, my lord, I'm challenging the total, my lord. The respondent number 5,
Who are you?
I'm a committee, my lord, committee which is formed for the interest of the proper interest and welfare of the Nepali community. my
So do you have a right that only Nepali people
lord.
can
I'm
have?
also not on that, my lord.
That is the most important thing. Who are you? Why should this court at all entertain your petition?
Yes, my lord, I'm not registered.
If
voter.
the KAC does, it's a different thing. But why should this court entertain your petition as a person? Your a vote object out there is that there should be no Nepali people who be purchasing any land.
No, my lord, not only that. my
Yes,
lord.
that is the reason why.
No,
But the ARO has done it for not only two other reasons, but another reason is the KAC. The KAC has not challenged the decision. Why should this court entertain your petition?
the land was transferred without prior permission of the council.
Why? No, forget about the council. The council has not come before the court. The council is not challenging. Who are you?
I understand.
You are a
that the-
third party. You cannot do so. What do you say, Mister? Because you see, if the KAC comes, it's okay.
My lord,
We may
are not-
consider.
My lord, we are not coming, my lord, because my
But
lord,
but you see the object behind the
My lord,
petition.
my lord,
That cannot be
my lord,
allowed.
my lord, my lord, the
I would have
order,
understood even if the
My lord.
Karbi people come.
my lord,
Then also I would have thought
my
about
lord, my lord.
yes, it is a thing because it is the authenticity of their thing or their existence is the question out
But
there for which.
The ARO has no power to cancel the patta. That is the basic issue. But ARO passed the order. Against that, they can prefer an appeal, my lord. That appeal lost, they lost, my lord. It's nothing.
And not only that, yes,
lord.
as you say,
My
the ARO doesn't have. It is the patta. If we use go
Want to cancel
as
it,
per
my
the
lord?
Assam Land and Regulation,
My
it is
lord.
only the commissioner.
My lord, and
26.
in our case, my lord, executive member in charge of the revenue, my lord. That is under Rule 26, my lord.
They can
But
only do.
they can do it, but not by like that, my lord.
ARO can have
My
done
lord,
that.
my lord.
And
Yeah, and
it is a very
for
serious
permission
thing.
also, it is goes to the secretary revenue, not to the my lord. If it is the my lord transfer to from a non-travel to non-travel, there is a procedure and there is a penalty is there, eviction is there, but cancellation of patta is not there. That is the law, my lord. That's really my lord.
What they have done, the very serious thing.
My lord, my
My lord, I have paid for the society, my lord. The society, local society, not a disturbed society, my lord.
I answer that. I am not asking you. You
And
take
my
your
lord,
seat down.
It may order, my lord, from
If
ARO.
Mr. Chauhan, if I have to allow the repetition, then I would have heard. I'm not disturbing it. Don't have a-
I leave it alone.
First of all,
No.
as Mr. City has rightly said,
Yes, I understand.
where is the power of the ARO to cancel?
Yes.
There is no business to cancel the patta. The cancellation has to be in terms of Rule 26.
my Rule 26.
It has to be done by the commissioner.
My lord. Yeah.
And in this case, the
Executive
secretary,
member in charge of revenue, as we have amended Act
so executive member in charge of
of
revenue.
revenue.
This has been done. So for other reasons also, this order cannot, the order of cancellation cannot subside. I'll come at 2.
Oh, yes.
And if you want the repetition to be allowed, I can hear you.
I know, my lord, where I stand.
2014, passed by the Assam Board of Revenue in case number 78 RA bracket KRB bracket close oblique 2010. From a perusal of the repetition as well as the impugned order, it revealed that the respondent number 5 herein had purchased a plot of land measuring 5 biga 2 katha 7 letter covered by dark number 9/49 of PP number 99 situated at village Tiniali, Non-K, Moza, Langpar. It appears from the impugned order itself that the respondent number 5 purchased the same after obtaining the permission from the ARO will be the assistant revenue officer. And the land has been also, and the land thereupon was also mutated in the name of the petition, respondent number 5. Thereupon, the petitioner herein, who claims to be a society, had approached the assistant revenue officer for cancellation of the patta which have been issued in favor of the respondent number 5. The assistant revenue officer thereupon, by an order dated 24/9/2009, cancelled the patta which have been issued in favor of the petition. Subsequent to the same, the Joint Secretary of the Karbi Anglong Autonomous Council, by an order dated 2/3/2010, was settled with the petitioner.
Page number 17.
Was settled in the name of the respondent number, in the name of an institution, namely Nepali Vishnu Mandir. The respondent number 5, being aggrieved by the actions of the respondent authority, had filed the appeal before the Assam Board of Revenue, which have been registered and numbered as 78, case number 78 RA bracket KRB/2010. By the impugned order dated 7/4/2014, the order passed by the Assistant Revenue Officer dated 24/9/2009 was interfered with, as well as also the consequential order dated 2/3/2010. And the learned Assam Board of Revenue further directed that the patta be restored in favor of the respondent number 5 and the land records be corrected accordingly. Being agreed, the petitioners have approached this court challenging the said order dated 7/4/2014. I've heard the learned counsels for the parties and have also perused the materials on record. This court have also taken note of that the reasons assigned by the learned Assam Board of Revenue, and is of the opinion that at the instance of the petitioner, the said at the and this court is of the opinion that at the instance of the petitioner, the said impugned order dated 7/4/2014 cannot be interfered with. Full stop. Further to that, this court also takes note of Rule 26 of the Assam Land and Revenue Regulation 1886, which have been duly adopted by the Karbi Anglong Autonomous Council. And as per the said provision, it is only the commissioner, and in the case of Karbi Anglong Autonomous Council, the executive member revenue,
Executive member revenue.
revenue, who has the authority to cancel the patta. However, in the instant case, as the patta was cancelled by the assistant revenue officer, which was absolutely without jurisdiction, the impugned order, this court finds no reason, therefore, to interfere with the order dated 7/4/2014, passed by the learned Assam Board of Revenue. Taking into account the above, the instant reputation stands dismissed.
Rule 26 of settlement rules
The settlement rule framed under the Assam
Assam
Land and Revenue.
and the Assistant Revenue Officer of Puloni Revenue Circle.
Hmm?
Assistant Revenue Officer ARO, there is a Puloni Revenue Circle. His circle is there. He passed the order.
Okay, the assistant revenue officer cannot do.
So,
It
my
can
lord,
be
my
done
lord,
only by
it's a
the
circle.
executive. Puloni Revenue. Circle.
Item number 4 and 5.
Yes. Now you have got your companion now, Mr. Sahu. Now both of you are saying is that this amendment has not been brought into effect by them. Why?
Because of
Huh?
it.
So
What?
So you mean to say every time there is an amendment, it has to be legislatively incorporated?
In that case, because the principle is that section 8 of General Closes Act. And that General Closes Act says it's about two types of legislation. One is legislation by incorporation, and one is legislation by reference. So, difference between legislation by incorporation and reference is that if the legislation is reference legislation by incorporation, in that case, any amendment made in the earlier act shall not affect in the later.
Now tell me, in the case of the Finance and Taxation Department,
Yes.
was it by legislation by incorporation?
Yes, because section 8.
No,
Section-
no.
General
Let us not go by the section 8. That section 8 we'll look into it later on. I'm not on that.
Will-
Here, what is being applied as per you?
that my office memorandum, the department office,
What does it say?
that says HSLC, seniority come, merit and qualification is 8.
Show me that.
Yes. Whether that record is there.
Hmm.
That is at page 27 of our equity.
No, let's see 17 of your review petition. Page 17 of your review petition.
My yeah, there is. It speaks about me. Third paragraph.
Hmm.
Third paragraph, thereafter that one. Find out the names of the
as there is no service rule about the establishment of the subordinate offices under the commissioner, the Assam Ministerial District Establishment Service Rule 1967 is generally followed by subordinate officers for guidelines. Wherever necessary, according to the provisions of clauses so and so, the rules amended by job notification so and so, 10% of vacancies of LD assistant in the year is to be filled up by the selection on the basis of seniority, some merit from among the therefore staff of the establishment concerned who have passed HSLC equivalent examinations, who have rendered at least 7 years of continuous service of on the first day of the year in which the selection is made. And this was brought from the Assam Ministerial District Establishment. and without page 75 of their review petition that supports this people. Yeah, they have annexed one document from the authority, and it up page 75.
Yes.
Very good. That second paragraph. It is transparent that from the views of appointing officers that promotion of their for employees is governed by city circular so and so. And there is no service rule for the subordinate officer under the commissioner of taxes, Assam so and so ministerial district established service rule is followed as guideline. City circular number so and so therefore becomes binding in the matter of promotion of grade 4 employees, while the Assam ministerial so and so rule supports as guidance only. The state circular stipulates the minimum qualification of grade 4 employees as SSLC passed in affecting the promotion of the state circular is strictly adhered to. Further in promoting grade 4 employee, there is no provision covering the departmental promotion committee, either in city circular or in the
How are you saying that, Mr. Gogoi? How are you saying that about the confirmation? That both were confirmed together on the same day.
Well-
Both the review petitioners were confirmed together, although he was earlier appointed. But whether the moment he is confirmed, in view of the direct recruit judgment, wouldn't he come back to the position of that same position? His seniority will be taken as on that date.
Yes.
Friend, how are you saying out here in page number 93, paragraph 6 of your reply?
Well, so Dilip Chandra Kolita, he joined on 1794.
Yeah.
Leonardo Deca joined on 23, 1998.
But you are saying that as he both were confirmed on the same day, and as such he stood over. How is it possible?
No, but otherwise also we have only stated that Dilip Chandra Kalita is otherwise senior. So he has joined in 94.
Understood. But what do you say? Since the confirmation date is common to both of them, by the joining department earlier by so and so put age over demand and bears the clear implication that so and so is
Or
senior
even
to
if
us.
we take
Hence,
that, my
it
lord, we-
appears the contention of here claiming seniority of here is correct and supported by
or even if it is taken as my lord, date of confirmation should be considered. Then also, my lord, since the date is same, date of confirmation is same, we'll have to see the date of joining. In that case, Dilip Chandra Kalita is senior. Otherwise, this is in my lord reply to the environment in para C of the ground. There, my lord, the review applicant has taken this plea that my lord, they both have been confirmed on the same day. So we have replied to that effect.
Now, what do you say about this thing?
My lord, your will kindly turn to that page. My lord. Page 13.
This office memorandum.
Yes, sir. Lord, we will see the content sharing. It says, my lord, in the absence of the rule, as there is no service rule for the establishment of the subordinate officers under this commissioner, the Assam Ministerial District Establishment Service Rule, so is generally followed. Now, this is a general rule that is already there for the employees of the state government. my lord.
No, it is not. Not for everybody. That is what I was looking into. Finally come to that. But another interesting thing
Right.
is the other one, the earlier rule, the 73 rule.
The director is working.
These rules shall be applicable to the ministerial staff of the office of the head of the department mentioned in column 1 of the year. Government may from time to time amend the clause 1 and any. That is the Directorate Establishment Ministerial Service Rules 1973.
My lord.
Now out there in the schedule, if you find, you will find the taxation department also. The commissioner of taxes, head of the department.
No, my lord, here may I clarify.
Hmm.
So far as these particular promotions are concerned, this has been done, my lord, in the unit wise, like in the district office. Under the commissioner of taxes
These are
office.
not directorate.
No, not the director. But
So
it-
in that case,
Yes.
you don't have a parameteria provision like 1, 2 in these ministerial district establishment rule. Here you
yes,
see,
like 2 minutes. Yes,
uh,
1 and
and 214 defines what is the district establishment. Means and includes all non-gazetted ministerial staff in the office of the deputy commissioner so and so of the district. Office of the deputy commissioner and subdivisional officers shall include branches like supply, textile, election, revenue, excise, development, and other branches. With this note, would it come in? and other general branches would this, it will come in. See, kindly see Assam Municipal District Establishment Service Rules 1967.
Yeah.
You see, section 2(4) defines district establishment.
Means and include all non-gazetted ministerial staff.
Then you see, note, Office of the Deputy Commissioner and the subdivisional officers shall include branches like supply, textile, election, revenue, excise, development, and other general branches. Now, with these other general branches, can you bring in the taxation? Because these are only circulars. The
Well,
circulars cannot override the act or the rules.
that
That there is no quarrel. But would this note, these general branches
my lord,
would include
will it include the office of the my lord, assistant commissioner of tax?
any of the district establishment?
Right.
Because this is a very important thing, because you have included. Why they have? Because you still see, finally come to schedule 1 of the earlier, that book of the earlier one, the
Yes.
directorate establishment. You see schedule 1, you see the various departments, see land record, cooperative society, industry, sericulture, forest,
Serial 14 is the
everything
commissioner
is
of-
there. All these departments are there, veterinary, science, you see the departments, revenue, cooperative, industry, sericulture.
Serial 14 is
Forest.
the my lord, commissioner of tax.
Huh?
Schedule 4.
Yes.
189. Head of the department.
180,
189 page. Schedule 4.
Ah,
Serial
head.
14.
please put that. No, this is for here. No,
Director.
no, why I'm saying schedule 1, finally see schedule 2. See the department, revenue, cooperation, industry, sericulture, then you have the finance and taxation. See? Where you have number serial 12.
Yes, sir.
Now, whether and other general branches, would it mean this?
No, branches, my lord, this is directorate. No? So far as this particular.
That I know.
Yes.
You see, here, finally come to the municipal district establishment rules note.
No, that I have understood. Yes.
You see, they mention branch and include branches like supply, textile, election, revenue, excise, development, and other general branches. Whether the other general branches will include the finance and taxation.
My lord, all probability it will include. That's why,
It
my
should
lord,
include.
yes. That's why, my lord, the commissioner of taxes has issued this particular OM, referring to this particular district establishment. Group.
No, this is a different thing. What he has done is, as we don't have a service rule, so we are going to follow.
Follow. Yes.
That is
Now,
another
whether
thing.
subsequent amendments will automatically come in or it will have to be again subsequently.
Because
notified.
what has happened, one of your assistant commissioner of taxes have written a letter to the commissioner.
Yes.
That I don't know how far can do.
No, that part, my lord, that is not an authority.
No,
trying
he's
to
not
say
an
is
authority to say all these things.
Yes.
But the which issue is whether all and other general branches,
I know.
would it include all other departments
Fine.
where they don't have a rule?
Will otherwise cover.
Hmm?
I said it will cover, but my lord, I will have to have the instruction. At the same time, my lord, there was a communication from the government regarding this, my lord, irregularity that has been going on, where, my lord, persons have been promoted from grade 4 to grade 3 without adhering to the amended criteria prescribed in 1967 too.
Hmm.
The report was called.
Hmm.
In fact, one of the officials of the directorate who was supposed to be selected to the or elevated to IS, my lord, that issue came up. He was, my lord, held up for integrity. And
No, obviously, because you see,
then report was called for.
because if all other departments,
Yes. They
now
are
because
following,
of
my
the
lord.
note,
Fine.
because of the note,
My lord.
as of now, for supply department,
Yes.
general supply, textile, election, revenue, excise, development, there these rules will apply.
All under the deputy commissioner, my lord.
They will apply.
Yes.
But however, are you saying that the finance and taxation would not apply? It will have a Article 14 violation.
Unless and until there is a specific rule, my lord, of a particular.
Because this
we don't
circular
have a-
cannot override this.
Yes, ma'am.
So you take an instruction on this. What do you mean by the other general branches?
And my lord, this here one submission I would like to make. My lord, this particular office memorandum nowhere states that, my lord, we are adopting this particular rule.
Hmm.
Because there is no question of adopting this. Being a government department, we are
Hmm.
bound to. If there is no service rule, we are bound to follow this, my lord, service rule.
No, here it says, as
As
there is no
rule,
service rules so and so, under remand, the Assam Ministry is generally followed by the subordinate
this generally
guideline.
follow.
For
What is-
guideline.
Yes, my lord, reflecting that, my lord, this will automatically apply.
Hmm.
It will otherwise
Because
it can-
this circular, in my opinion, this circular cannot override.
Sir.
And it will have far-reaching consequences
My lord.
if those departments are not there. You get an instruction on this, put it on by way of an affidavit.
Lot.
Huh.
Whether, my lord, under general branches, our assistant
And,
commissioner. will
and
cover.
this affidavit has to be from the commissioner.
Commissioner of taxes,
No.
government,
Commissioner and secretary,
lot.
finance and taxes. Because then when
Yes.
he says,
Yes.
it will have an effect. Not the commissioner of taxes is just an statutory authority out there.
Lot.
But the commissioner of, and say is for the government.
Lot, we will indicate it, man. Fine.
No, it would not require. If it is comes within the general branch.
It comes there.
Get the point? If it comes under the other general branches, then you don't require it. Automatically it will come in.
That is
That is what I am saying. Let him come up with an affidavit as to whether the term other general branches will include the departments, including the finance and tax.
Lot, we will indicate respond number 2. It is the commissioner secretary, finance taxation department.
Mr. Sharma, are you saying that the circular would override the act, the rules? I'm saying, okay, this is being done by whom? By the Commissioner of Taxes. Commissioner of Taxes is only a statutory authority out there, which is done under the particular provision of the act. But you see, we want to know what is the stand of the government. It is not the government. A circular issued by the Commissioner of Taxes cannot be the recruitment rules. The recruitment rules has to come from the government. Mr. Sharma, why you are not understanding the basic philosophy? You see, a recruitment rule, can it be done by the Commissioner of Taxes? Or even just, for example, any other director? No, can tomorrow the director of secondary education come up with a circular? No, it has to be the decision of the government. The government will be represented by the commissioner and secretary. So therefore, it has to be, therefore, a circular should have, normally, therefore, you will see this, otherwise, the commissioner of taxes has to be delegated that power by the government. This circular, on the face of it, is not tenable because, in my opinion, I don't know if I'm not, may not be right, but my prima facie opinion is a circular as regards anything about recruitment has to be by the government, by the department head. Because you see number 5, government means the government of Assam. This court, upon hearing the counsels appearing on behalf of the review petitioners, as well as Mr. B. Gogoi, the learned standing counsel of the Finance and Taxation Department, have put a specific query upon Mr. B. Gogoi, the learned counsel, as to what would be the meaning assigned to the term and, inverted comma, and other general branches, inverted comma, close, and used in the note to section 2(4) bracket of 4 of the Assam Ministerial District Establishment Service Rules 1967. Further to that, this court also would like to be apprised by the respondent Finance and Taxation Department as to whether the Commissioner of Taxes has the power to adopt or frame recruitment rules or has the power to adopt or issue executive instructions as regards the recruitment in the subordinate offices of the district establishments. In this regard, this court again fixes the matter on 6th of February 2024. In the meantime, the Commissioner and Secretary to the Government of Assam Finance and Taxation Department is directed to file an affidavit answering to the queries so raised. Because this is very pertinent. They let us know the government stand.
Earlier, copy of affidavit,
What?
copy of affidavit, whatever 25.
Now you take it from your friend who is now your partner.
But in
Mr. Google, give him a copy.
why not?
He's supporting your case.
Problem.
Yes.
This is petition filed against the Lordship allotment order.
Huh?
Allotment order, Lordship. Leased by the
By
Lordship
the
Committee.
chairman, that is of the Padapur in leasing out and settlement of municipal properties without giving notice inviting tender for shall not be issued directing the chairman not to speak for settlement of the Padapur. And what happened?
Lordship,
In the interim allotment of the first state until the return of the date.
then it was extended. Lordship,
Where?
further on. For 8 foot.
When was it extended? Until the disposal of the writ. Okay. So as of now, there's a stay.
Stay.
Now the only question out here is, can the chairman,
Lordship, without issuing tender, Lordship.
without issuing a open
Lordship,
participating process,
can allot.
allot any
Now, Lordship,
municipal property?
I have quoted the rules, Lordship.
Rule
Lordship, notification, Lordship. And
notification of 1958.
that is this, for not two Lordship. This period for a total period of 2 years, but not exceeding 1 year at a time, Lordship. But that it is written in. In a particular-
There's a rule now. I've delivered a judgment on this aspect earlier. That you cannot do so without a notice, without a without forming any formality.
That was my, it was supported by the restaurant number 3 lot.
There's a rule, na? Rules of pounds and malls and what is that? এখন আছে না এই municipal act.
I quoted this. in my-
Rules for procedure for sale of pounds and markets by the municipal board and council.
Committee.
224.
Number 1, all bonds which municipal board decided to farm out and market established by the state
Uh,
in or place under control and
all pounds which the municipal had tried to farm out
Sir,
and
Mr.
mark.
Rules, procedure for inviting tender.
And market established by. Tender subject. Sale by Yes.
My lord, I am appearing for respondent 8 and 9.
Hmm.
Who are duly allotted the settlement in the year
How?
2011.
How?
And after our allotment, we're making the payment as we are not giving the settlement right. So we approach this honorable court now by filing a writ petition bin number
Another return.
in 2013, my lord.
Good.
No, this may not be there, my lord. In 2013, we filed a writ petition and that matter was disposed of. And thereafter, after the court ordered, we were finally given the settlement and we got the possession. But because of the writ petition they have filed in 2014, after our writ petition was disposed of. So we filed a writ petition number 3551.
Where is the order passed?
Order was passed on 14 to 2014.
Where
My
is it?
affidavit, your lordship may kindly see.
Huh?
Affidavit filed by respondent number 8 and 9.
Chandan Paul? No.
No, myself.
There is a miscase lordship, miscase is lordship 3255, sorry,
Affidavit filed by respondent number 8 and 9.
8 and 9.
Where? Where is that order?
Order is the last page, my lord. Last page I have annexed in the affidavit, my lord. Annexure 4, page 15.
Referring to an actual allotment, the case of which they are entitled to be paid. Okay. But anyway, the allotment orders have been put to challenge. Yeah.
No, my lord, they have put it, it has been put to challenge in 2014 by filing a writ petition here, my lord, whereas we filed our writ petition in 2013.
No, understood. You said that you have been made a settlement.
Settled.
Now, if the settlement is illegal, obviously, if it was given
No,
without
it is not illegal, my. According to us, there was a notification in response to that. we
where is the
applied for-
notification?
My affidavit kindly, your my affidavit may kindly be seen.
Where?
Paragraph 3, 4, my lord. That in response to the contention, paragraph 1 and 2 of the writ petition, I agree with the state contention and respectfully stated it is true and correct that the Badarpur Town Committee after construction of the building has market complex proposed to let out different rooms in the first floor of the building.
No, where is that?
No, in the whole paragraph 4,
No,
my
this
lord.
is your statement only. Where is that notification?
My lord, kindly see read petition page number 25, that one word.
Then we paid, they also received
Yeah.
our money, my lord, and then made agreement with us. This is not the agreement, my lord.
The manor lordship, you will find from page 22. lordship.
Hmm?
From page 22, lordship, manor lordship, the petitioner filed a complaint before the deputy commissioner on 9th of July 2014, stating that there is a lordship, kindly see complaint lordship 5/7/2002 lordship.
Who is
File-
appearing for Badalpur?
Government, lordship.
You are appearing.
I'm for the,
Government filed a affidavit lordship supporting my case.
Hmm.
Lordship,
Settlement-
on
settlement
5/7
was
lordship filed complaint
given by
lordship
the
before the
Badalpur
deputy
town
commissioner
clerk.
lordship for illegal allotment lordship. Then on lordship 9th of July lordship, deputy commissioner lordship directed the circle officer Badalpur to conduct an inquiry lordship. 9/7 lordship, at least page
Hmm.
20. Can I get?
Hmm.
And lordship on 10/7 lordship settlement document. Lordship, kindly see page 23. From page 23 lordship onward lordship. And with reference to lordship page 23, settlement to one Ray Diamond Tip. With reference to subject, I am to state that in pursuance to resolution number 9B, serial number 3, the ordinary meeting held on offense of this town committee authority is very pleased to allot the room to you, your NGO, on
And for how many years it has been given to you?
My lord,
For how many years? For a lifetime?
no, my lord, as per, we have got the agreement also, we are monthly tenant, we got the settlement, we prepared it.
No, no, for how long? No, if we see
for 10 years.
section 62, let us see section 62.
They made the complaint in July 2014, whereas we were given the allotment, the advertised one in 2011.
Any particular tank shall be leased out as a factory only after giving opportunity to the public in the submit tender for obtaining. In such procedure was not followed, the respondent have picked up from the purpose of granting lease and that took for a period of as high as 10 years and continuous. Hence, the settlement made in favor of the respondent.
The town committee received the payment of rupees 1 lakh from each of us, my lord. Not only 18
Then
amendment,
200, there is another section 200 something. 200.
There is a regular town committee presently, my lord. So let the regular town committee file the affidavit.
No. No affidavit. We set aside it. It's not done.
That is that, of course, my lord, but your lordship may kindly consider our case because
No, I can't.
No,
You have
what-
already enjoyed it. You have enjoyed. But
no,
this is not the manner in which it is to be given. But there is a, yes, Mr. Counsel, where is the provision out here? How it is to be
Lordship,
given?
rules to Lordship,
Rule? Not
to-
forget about
to
the rule.
Lordship.
I'm not the
the
rule.
period of lease for a pond or market shall be 1 year,
Yes, I
provided that the
see.
board may, if it thinks fit, with previous approval of the director of municipal administration, extended the period of lease for a total period of 2 years, but not exceeding 1 year at a time. Lordship. And Lordship, first Lordship, rule 1, all ponds,
Yes.
all
Not coming
ponds
to the
which
point.
the municipal
Kindly come to 148. The board, if decided in a meeting, may use their own land or with the bidding or land, but they taken on deed or otherwise acquired with or without bidding to the protection of municipal function or it could be. The board, if decided, the may levy of it for use of it, a grant is according to the rules under this section for a period not exceeding 3 years for collection of the 10 full. In the absence of the sub- they refuse to allow it.
says Lordship, all ponds
Where's the agreement? Okay.
There is a mistake. Mistake is there, and but the mistake C255 of 2014,
Three,
C255. Or that is two mistakes. C253,
Mistakes filed by some other
some
person.
other person,
Some other person, they are not there.
same date, same date allotment.
Huh?
Same date allotment, Lordship, four person, Lordship, same date allotment, Lordship.
who is this Diamond NGO?
They are not present here, man. They are represented by some other advocate.
You have been given for how many years?
My lord,
99 years. Have they taken the permission from the, what do you call, the Director of Municipal Administration? Did it taken? Any permission has been taken? Mr. Borgoyan?
I am not aware.
Absolutely no. How can you give it for 99 years?
The respondent number 3, Lordship, comment file affidavit. In their affidavit, Lordship, paragraph 9, that stated. The respondent failed to state that the lease agreement with some other private individual NGOs are not in accordance with the statutory provisions of municipal.
Hey, you can, that's when you get up there. (1992) TLR 109. 92 1 TLR 15. 15. Cannot do like. Who are the respondents here? Diamond Motor Drivers Association, Abdul Base. You are paying for 8 and 9,
I am myself for 89.
and 6 and 7 is this. Diamond here is given for 10 years, and you have been given for 99 years. Both. Fakhruddin, um,
Abdul Basit is respondent 8.
no,
and
no, 9.
9 is Fakhruddin.
He also 99 years.
As per the agreement, it appeared.
No, this is only for Abdul Base. You have given only one agreement.
There are two agreements.
There is also. Are you enjoying?
Because of the stay order, my lord.
You are not.
They have got the possession, but they are not allowed to construct the part. Only 170.
Construct? What is there to construct?
Stall, my lord. No, my lord. The first floor of the building has been constructed by the authority, and we are allotted the space of 171 square feet
Ah.
for small stall. So now burden on us to make the construction and avail the
Take
store,
only
whatever we like.
4 numbers of showroom of the ground floor, but further take the complete the same. If the northern of the second part, the completion the construct the peak of the appropriate their own and shall be not be read.
And now in our affidavit, we have annexed the payment of money of rupees 1 lakh to my lord as the demand.
Hello, I'll pass the order. All these settlement has to be set aside. Hello. One, two, and none appears on behalf of the respondent number 4 and 5, 4, 5, 6, and 7. Mr. N.H. Raj Borbuya appears on behalf of the respondent number 8 and 9.
Yes.
The instant writ petition has been filed seeking a direction of seeking a writ in the nature of certiorari for setting aside and quashing the impugned letters dated 10/4/2014 issued by the chairman in charge of the respondent number 4 of the Badarpur Town Committee, Badarpur, whereby the marketplace was leased out to the private respondent number 6 to 9 The petitioners have also sought for a writ in the nature of mandamus directing the chairman of the Badarpur Town Committee, Badarpur, not to proceed for settlement of Badarpur Town Committee Market Complex without following the statutory rules laid under the Assam Municipal Act 1956, for short, the Act of 1956. The facts, as is discernible from a perusal of the pleadings, is that the Badarpur Town Committee had constructed one two-storied building, approximately 3,400 square feet of each floor, for its office and for municipal market on the land owned and possessed by Badarpur Town Committee. After construction of the said building, the Badarpur Town Committee had let out the ground floor of the said building, measuring around 3,400 square feet to some individuals for the shops in the said market building complex. The office of the Badarpur Town Committee was proposed to be accommodated over 1,400 square feet in the first floor of the said building, and the remaining 2,000 square feet in the first floor of the said building complex was proposed to be leased out for their trade oblique organizational purposes of various organizations. The petitioner came to learn that the respondent number 5, who was the chairman in charge of the Badarpur Town Committee then, had carried out certain illegal activities of allotment of the remaining space of 2,000 square feet in the first floor of the market complex without following the mandate as per the Act of 1956 and the rules framed therein under. Under such circumstances, the petitioner submitted a representation before the Deputy Commissioner Karimganj District on 9/7/2014. On 5/7/2014. The Deputy Commissioner Karimganj thereupon directed the circle officer to conduct an inquiry by the communication dated 9/7/2014 and to submit a report. In the meantime, now immediately thereupon, on 10/7/2014, the private respondents number 6 to 9 were issued allotment letters which have been enclosed as Annexure 4 series. These allotment letters have been put to challenge by way of the instant writ petition. The record reveals that the instant writ petition was filed on 13/8/2014 and by an order dated 22/8/2014, this court had issued notice and in the interim directed the allotment of space on the first floor of the Badarpur Town Committee Market Complex by the in-charge chairman of Badarpur Town Committee made on 10/7/2014, Annexure 4 series shall remain state. The record reveals that the said interim order had been extended from time to time. In spite of receipt of the notice, the Badarpur Town Committee have not chosen to appear, have neither chosen to appear nor file their affidavit in opposition. Full stop. The private respondent number 6 and 7 had also not filed their affidavit in opposition. Full stop. The respondent number 3, who is the circle officer, Badarpur Revenue Circle, had filed an affidavit in opposition on 23rd of January 2015.
Number 3, let's say Deputy Commissioner.
What about the backup?
The respondent number 3 had filed an affidavit in opposition through the circle officer Badarpur Revenue Circle on 23/1/2015. It had been mentioned in the said affidavit that pursuant to the direction passed by the Deputy Commissioner Karimganj, the circle officer Badarpur Revenue Circle had started to conduct the inquiry, and in the meanwhile, and could see that in the meanwhile, some of the so-called lessees had started construction in the first floor of the Badarpur Town Committee building, and presently some RCC pillars have been constructed. It was also mentioned that the earlier lease agreement with some private parties and the NGOs are not in accordance with the statutory provisions of the municipal rules. The respondent number 8 and 9 have also filed an affidavit in opposition on 18th of July 2018. From a perusal of the said affidavit in opposition, it reveals that after construction of the building as a market complex, proposed to let out, the Badarpur Town Committee proposed to let out different rooms in the first floor of the building to the interested party, agreeing with the terms and conditions. And accordingly, the town committee, which was then being run by the in-charge chairman, namely the in-charge chairman, who is the respondent number 5 in the instant proceeding, invited applications following the due procedure of law, asking different persons to apply. It was further mentioned that in the month of November 2011, the Badarpur Town Committee notified in the local dailies about the decision of construction of the market complex consisting of 28 number of rooms. The respondent number 9, along with many others, applied for such room, and the respondent number 8 and 9 were selected along with many others. The said respondents thereupon deposited ₹1 lakh as required by signing the agreement. Though the said agreement is not a part of the record, but Mr. N.H. Rajbarbhaiya, during the course of hearing, has placed before this court the two agreements entered into with the respondent number 8 and 9. From a perusal of the agreements dated 16th of July 2014, it reveals that the respondent number 8 was leased out 4 numbers of shop rooms of the ground floor of the building. Was leased out. Was leased out. The northern side of the first floor of the building, with a condition that the respondent number 8 shall construct the building of the aforesaid portion with their own cost and shall pay the monthly rent of the aforesaid of the first floor of the building. On the various terms and conditions set out in the said lease agreement. Surprisingly, the said lease agreement does not mention as to the amount to be paid. This court have also perused the other terms of the lease agreement, which show that the respondent number 8 was to pay rupees 50,000 as security, and the period of lease was for 99 years with effect from 1st of July 2014, subject to renewal with enhancement at the rate of 15% of the existing rent after expiry of each 5 years. It is also relevant to mention that the said agreement is not a registered document. The agreement with the respondent number 9 is also similar in content. And for the sake of brevity, this court is again not repeating the same. Be it as it may, in both the agreements, there is a sketch map enclosed showing the indicated area of the shop rooms in question. Both the agreements with the respondent number 8 and 9 are kept on record and marked with the letter X and Y respectively. This court further finds it relevant to take note of that after the decision which was taken in the year 2011 to allot the rooms to the respondent number 8 and 9, the respondents, though paid the security amount, but they were not given the possession of the rooms, for which the respondent numbers 8 and 9 had approached this court by filing a writ petition, which was registered and numbered as WPC number 4351/2013.
No, my lord, this one number is 3551 of 2013.
3551 of 2000. No, it is 4351.
Oh, 4351.
Yeah,
Oh, yes,
I'm
my-
not
sorry.
4351/2013. The record reveals that this court, by an order dated 14/2/2014, had disposed of the said writ petition, directing the Badalpur Town Committee as well as its officials to consider allotment of the rooms to the petitioners. The petitioners therein, that is the respondent number 8 and 9 herein, in terms with the allotment order dated 27/2/2012. In the backdrop of the above pleadings, this court have also heard the learned counsels appearing on behalf of the petitioner, on behalf of the parties. This court had put a specific query upon the learned counsels appearing on behalf of the respondent number 8 and 9 as to whether prior to issuance of the allotment orders as well as entering into the agreement for 99 years, any permission was taken from the director, from the director or director, na? Director of Municipal Administration. Inasmuch as nothing appears from the allotment orders as well as also from the lease agreement as to whether such permission was duly taken. The learned counsel for respondent number 8 and 9, however, with all fairness, submitted that he has no knowledge about the same. So, in the backdrop of the above, this court therefore finds it relevant to consider that the perusal that in terms with section 62 of the Act of 1956 stipulates that all the properties mentioned in the said section situated within the municipality shall vest and belong to the board and shall with all other properties of whatever nature or kind which may become vested in the board be under its direction, management and control. Amongst the various properties, it includes markets, slaughterhouses, public buildings of every description which has been constructed or are maintained out of the municipal funds. Section 64 of the Act of 1956 stipulates and empowers the board to enter into and perform any contract necessary for the purpose of the Act. It stipulates that every contract made or on behalf of the municipal board in respect of any sum exceeding 500 rupees or which shall involve a value exceeding rupees 500 rupees shall be sanctioned by a board at a meeting and shall be in writing and signed by at least 2 of the members, one of which shall be the chairman or the vice chairman and the executive officer, and shall be sealed with the common seal of the board. Section 63 further stipulates that the board would have the power, that no board shall have the power to sell, let, exchange or otherwise dispose of any land vested in it under Section 62 except with the sanction of the state government. This court also finds relevant to take note of the provisions of Section 148 of the Act of 1956, which empowers the board to let out municipal markets as well as shops, stalls and standings therein. In terms of subsection 3 of Section 148, the board has the power to grant a lease according to the rules framed under this section for a period not exceeding 3 years for the collection of rent, toll and fees in municipal markets, parking lots at the rates prescribed by the board under subsection 2. In the backdrop of the above, this court also finds it relevant to take note of the rules rules for procedure for sale of pounds and markets by municipal boards and town committees, so framed in exercise of the powers under section 147, 148, and 301 of the Act of 1956. From a perusal of the said section, of the said rules, it is apparent that that all pounds which the municipal board, pounds POUND, which the municipal board decides to farm out and market established by reveal that all pounds and markets shall be farmed out, FARME, by a tender, subject to observance of the rules and procedure for inviting tender. It further stipulates that a period of lease for a pound or a market shall not be for 1 year, provided the board may, if it thinks fit, with the previous approval of the Director of Municipal Administration, extend the period of the lease for a total period of 2 years, which but not exceeding 1 year at a time. At this stage, this court also finds it relevant to take note of the judgments passed by the division bench of this court in the case of Sarat Kumar Neok versus the state of Assam and others, reported in 1992, 1 GLR 152, wherein it was categorically observed by the division bench that if the period of lease is for 1 year, the board has the absolute power to grant the lease of the market. But if the period of lease is for more than 1 year, it is to be made by the board with the previous approval of the Director of Municipal Administration. Paragraph 5 of the said judgment, being relevant, is quoted hereunder. In the backdrop of the above, if this court takes note of the facts of the instant case, there is nothing which could be shown before this court, nothing which has been placed before this court, that any public auction was invited as regards this for the purpose of leasing out the municipal market of the Badarpur Town Committee. This court is further shocked and surprised to peruse shocked and surprised upon perusal of the agreements which have been kept on record with the and marked with the letter X and Y, as well as also the agreements entered into with the respondent number 6 and 7, which are part of the instant proceedings. In the said agreements, the lease have been granted. In the agreements entered into with the respondent number 8 and 9, the lease is granted for 99 years. Whereas in the respect to the lease granted to the respondent number 6 and 7, it is for 10 years. Under such circumstances, it is the opinion of this court that the allotment which have been made in favor of the private respondent number 6 to 9 is in flagrant violation to the provisions of the Act of 1956, its rules as well as the law laid down by the division bench in the case of Sarat Kumar Neok Supra. Under such circumstances, the allotment letters dated 10/7/2014 issued in favor of the respondent number 6, 7, 8, and 9, bracket annexure 4 to the writ petition, are all set aside and quashed. The consequential effect of the quashing the said and the said allotment letters is that the agreements which have been entered into with the respondent number 6 to 9 are also set aside and quashed. This court also cannot be unmindful of the fact that the petitioner, that the respondents number 6 to 9 had also paid certain amounts as security.
1 lakh.
Certain amounts as security. Full stop. In view of the setting aside of and quashing of the allotment letters, they would be entitled to the refund of the said amounts which have been paid by them as security. Full stop. The said, the Badarpur Town Committee shall refund the same on production of the necessary documents within a period of 6 weeks from the submission of the instant certified copy along with the documents. This court further directs the respondent authorities, more particularly the Badarpur Town Committee, to take appropriate decision for, if deemed fit, for leasing out the Badarpur Town Committee market in accordance with the provisions of the Act of 1956 and the rules framed therein under.
All right.
I say stop this.
My lord, I have my instruction. Some other persons also deposited, my lord. In fact, I have in my affidavit, I annexed his name. So
Not necessary. This I am only with 6 to 9. Others are not there. I have not challenged the others. Na. Nobody has. He has not challenged the others. He has only challenged the allotments of 6 to 9. So I am only setting aside them. The others, if they are not challenged, I can't help it.
is good.
Hmm.
My lord, his oral report was pleased to call for records of the case in previous occasion.
What?
In respect of number, respect of the mark sheet, my lord, details of the case, my lord. Last occasion,
Oh,
last occasion, previous. Report was called for.
yes, Mr. Bhartwaj, what is this? No, no records call.
What has happened is the retail outlet was advertised in the district of Puri.
Hmm?
The district of Puri retail outlet, assessment of a retail outlet was advertised by the Indian Oil Corporate Limited. He applied, along with her 9 other candidates also applied. Now, there's a provision in the guideline for someone who avails for this retail outlet has been reserved for women, open category, but women. Now, there's a provision in the guidelines which says that if women, if some of the women avail for corpus fund, then the entire interview under the categories capability to provide infrastructure and finance. Even if one woman applies for the corpus fund scheme, then all of the candidates shall not be judged under these 2 categories. Rather, all of them will be judged
over the remaining categories, say age, ethics, qualification. So in the interview, she came last. We prepared a panel list. We declared the results, and the panel list, there were 3 candidates. So she came to this honorable court and we obtained the status quo. As on date, we have not proceeded with the status quo. That is her case. The only
So what
ground
are you thinking of doing it? This matter? I
Uh,
think this matter came up before this court.
they have,
And I asked you, what do you propose to do with it?
my lord, my latest instruction is that this falls among the old pending matters of IOC. So we have to argue for, we have to place our final argument.
Huh?
We have to place our final argument.
You place your final argument. No, I'm not on that.
My lord,
Does the
no, it's clear,
IOCL
it's
still
clear, yes,
wants?
yes.
Yeah, that is
My lord, these, their evidences are not as per guideline. Guideline. As such, this Honorable Court was pleased to call for record of the case.
No record.
Land document, land mark was not stipulated.
Wait, Mr. Counsel, kindly come. Records have not been put. Let us first know what is the case. Tell me what is the case.
Well, it is appointment of retail outlet dealer for that. 30, then Balajan, location Balajan. In the advertisement, serial number 81 of the case. As per their APDPD in opposition, they have submitted there. They have submitted that these land documents, land parameters marks is 60 marks and other 40 marks. But they said that the purpose fund is available because 7, 8, 9. 7 is now expired. 7 is now expired candidate. 7 is now accident on 2019 in the year 2019, 10 June. 8, 9 is here. No private respondent have filed any reply in this regard. No file. 8, 10, no file. Official is not filed. After having RTI, my lord, as per in the RTI application, the father of the petitioner called for the landmark, but they refused, denied to submit the land document of other candidates. My lord, in their affidavit, my lord, they call the, my lord, kindly see, my lord, in the land documents, my lord, land documents are not evaluated, my lord. Are they call for there who are women above 40 years, poor, non-earning, are have to opt for corpus fund. No any candidate, my lord, opted for corpus fund. The 7 is extra, 8, 9 is not in the petition submitted opted fund. Opted for document. Record of the case was called for by this Honorable my lord. I will see the case. In the affidavit, they submitted that 4 candidates are opting for purpose fund. Who are 4 candidates? Who are the 4 candidates? Then they did not disclose.
Okay. Now let us make it based. Where's your marks? Where's these marks?
page 87.
Huh?
Page 87.
Marks. What is your name?
Mr. It is
Huh?
Jutika Roy. Jutika Roy, serial number 4.
petition name is Jyotika Rai. I am in the 4. I have submitted only a land document.
Jutika Roy. Jutika Roy. Wait.
Annex 54 guideline.
page 8, para 8-9, for the provision, 55, for first time. Page 55. My lord, on last.
No, understood. You see, if we read clause 9D, it
Hmm.
says for determining the priority to be given to such candidate over other women, the marks secured by other women under these two parameters. That is, parameter pertaining to capability to provide infrastructure and facilities and capability to provide finance would be excluded from the total marks secured by them.
Hmm.
So that will be not taken into account. So marks avoided in interview, marks to influence, so liquid cash, fixed assets, income, letter ensuring credit, total so marks avoided by the investor. These are all not taken into consideration. So what was taken into consideration was the educational qualification which it could have been taken. Okay. Next come is tied up volume. Now what is this?
This comes under the capability to generate business. Tied up volume project report.
Capability to generate business. This has nothing to do.
This is not excluded. This is included. Clause.
Where are these capabilities
Yes,
things which are to be considered?
Page
90, my
57.
lord.
Page
57.
55.
57.
Capability to provide land and infrastructure and covered finance. So these 60 marks is not considered.
No.
So 60 marks is not considered. Considered educational capability to generate. This is being considered. Then project report is being considered. Overall assessment is considered 10 marks. 10 marks. And what is the maximum is 25. What is this 25? Maximum marks non-individual entity. This is individual including partnership. So this is 10 marks.
Yes.
So these 10 marks, what she has got is something like 385 and 133. Anyway, then age.
Age, everyone is given the top mark.
Age is 4 marks.
Because
Experience is 4 marks. Business acumen, 5 marks. Personality, 2 marks. So total is, you have taken in how much? You have not taken 60, na? It is
we have
40.
not taken 60. Yes.
Out of 40.
Yes.
Out of 40, 65 you have not taken. Out of 40,
She is the last.
she got 26.13.
Being the last.
The number one has got 30.67. Number 2 is 38. Then 32.
32.
Okay. She has got only,
26.18.
where is the name?
Yutika
Yutika,
Roy.
number 4.
Yes.
1, 2, 3, 4. 26.13.
18. Yes. 18.
18.
My lord, land aviation mark is not considered.
Huh?
Land mark, 60 marks. Because
The 60 marks cannot be considered.
why not? As per now, it's not done as per browser. Kindly see 55 browser 9B. Page or
Yes, what does it say? What does it say?
subject to the application and request, widows and unmarried women and above 40 years of age without earning parent for locations reserved for women will not be judged under the hard capability to provide infrastructure of facilities and to capability to provide finance. These applicants will be required to indicate in the application form itself whether they will like to avail the corpus fund facility. In this case, this is no indicated in the application form. It will be constitute that such application would like to get evaluated in with other application. That is, they would also be assessed under the head's capability of provide inspector and facility. Capital. For provide investor. For determining the priority to be given to such candidates
of other women candidates, he makes execute by the other women under these two parameters will be excluded from the total marks accepted by them. My lord, three candidates, 7, 8, 9, expired. My lord, they in the application they not accepted for purpose fund. One is student number is the daughter of the DFO, SDFO, not under the category. All are the all petitioners, all candidate incumbents did not file any except Sam Ahmed.
Did you ask for purpose?
Huh?
Did you ask for purpose?
No, my lord, I also not. I am about 40 years unmarried woman. 2, 8, 9, they are not acceptable. So they have filed affidavit in affidavit.
No, I am asking you, did you avail corpus fund?
No,
You did not.
no,
Means nobody did.
nobody. Only in their affidavit, they go 4 candidates are asked for purpose fund. Who are they? They are not mentioned the name.
Yes, who has asked for corpus fund?
My lord, in our affidavit, although we have stated that only 4 candidates have availed for corpus fund, we have not specified the name. But from the readings what I could gather of my learned friend, my lord, it is not their case that none of the candidates have availed for corpus. It is only that her land, her capability to provide infrastructure and finance, that mark has not gone. That is her case.
My lord, is a browser is a 31B. Is the advertisement browser land document are called for. Land document are called for. So after the interview, no land document will be taken. Why it is mentioned?
Forget about land. Land is not required. Somebody has taken the corpus fund. So how do you judge? Tell me.
As such, it is placed with the zonal code. These zonal code are pleased, my lord. Only in previous.
Now what happened? Just for example, let's say there are 4 persons, you will say, who have availed the corpus. Of these 4 persons, that means you are going to adjust with 40. First you adjust it with 40. There are 9 candidates, or how many candidates? 9 candidates.
Yes.
9 candidates or 8 candidates.
10 candidates who were accepted.
Of these 8 candidates, a person who has opted for purpose fund, that while taking note of that, first we are going to look into it as to whether within the 40 marks, how much. Now, once that person is out, then how do you identify the others?
Understand? But the guidelines say, guideline is very specific, that you have to let go of these.
Understood. When it is only the corpus fund for those. But if just for example, two persons have asked for the corpus fund and they have got only 10 marks out of 40. They are out. But how do you judge the other 7 then? Other 7 then has to be judged on the basis of that. Isn't it so?
Even
Unless you say that yes, amongst the top 4 or top 3 where he was there, one of them had applied for the corpus. If that's so, just for example, the person number 1, she had applied for the corpus. And then as such, you have to take with them only for 40 marks. And then the question would be different. Then in that regard, it is not required to look into. But if it is down below, those 2 have applied and they are out, just getting 10 marks out there, then you are to decide the others thereafter by taking into account all the others, because otherwise it will become useless. I think that should be the proper meaning to that corpus fund business, because the why it is there, a person may not be having earning capacity. A child, unmarried daughter, she may not have all these things. So under such circumstances, she can apply for the corpus. Now, once you apply for the corpus fund, that person, while you are taking into account that person, then you don't take note of the 65 marks, the rest of the 60 marks. Don't take note. You do only with everybody. But if that person is out,
That-
then don't you think that the others have to come in?
In that circumstance, my lord, we have to figure out whether we have to know from the records whether page 86, the panel list, whether these three falls under the scope of
Any of these.
Any of-
Number one, number two falls within. If number two also falls in, because he's number four, 1, 2, and 3, if anybody is there in the corpus one, then you have to, she's out.
But one more thing, my lord, he is the last case.
Understood? No, she's the last candidate amongst the 1 to 4.
He is the last candidate among
I am
all,
four, I am
all
four.
8.
Huh?
Among all 8.
No, I am four.
56.18 is the last mark.
Oh, then one is absent. 2 is absent. Out of the 10, 2 is absent. So you are last. Then one will have a corpus one. Now, whether these 2 person who is absent, did you apply the corpus fund because of these 2 person who were absent? But then also she would not.
Yes.
In no case.
Last candidate of all 8.
But then also I think as the repetition has been pending from 2014.
My lord, I can
My
get
lord,
that.
can
Give him one satisfaction.
Yes, yes, yes.
My lord,
Certainly.
my lord,
We'll have it on Thursday.
Well-
Short question, short answer.
Yes.
As to whether who were the people who have applied for
Who are
corpus
those
fund,
4 candidates?
4 candidates. If anybody is above him, anybody who has applied for corpus fund is above him, then he's out.
my lord, my lord.
You don't have any case thereafter.
My lord,
But our only satisfaction is 10 years the matter has been pending.
My lord.
Is
my lord, my senior is out of station.
no senior business. Matter is over. No senior junior
My
business.
lord, my lord, on the last TV education, I can, and I give it a
Mr. Counsel, no
Deputy
senior,
Commissioner.
no, sorry, no senior in your business. I'm finishing it on next Thursday.
next,
Thursday,
Puru-
heard in part, list the matter again on 8 for further, yeah. For further consideration on which.
my lord, I will be out of station, my
No,
lord.
no,
After vacation, my lord.
no,
After vacation, my lord.
no, on 8. Mr. P. Bhartwaj, the learned counsel appearing on behalf of the respondent shall apprise this court on the basis of the reports as to whether who were the candidates who had applied for the corpus fund and whether the who were the candidates who had applied for the corpus.
My
You
lord.
just find out that.
My lord has indicated record from Puri. So
No.
if scan copies are also.
Scan copy.
Well,
Just find out that who
My
had
lord. My lord, my humble submission
and
before
produce
this
scan
honorable, my
copies
lord.
of the
My lord,
of the relevant part
on which day, my lord?
Thursday.
after it.
Sorry. আজকে কই? খবরই
Purohit.
করে না।
That-
Well, I will be out of station, my lord. After vacation, my lord, after vacation. I will be after,
Mr. Counsel, I've already spoiled so much of time. Matter is over. Only question is this type of matter shouldn't be there for such a long time.
my lord, it is totally not in the record of voucher, my lord. Kindly peruse after perusing the voucher content of the advertisement.
Next. You, whatever you have to say on
Number 10.
Thursday.
May I please? Before my learned senior starts, my lord, may I point out one thing, my lord? The Stone Kasar unit, who is owned by the respondent 10, my lord, whom I am representing, he died during independence.
Who died?
The proprietor of the Stone Kasar unit. No. Next.
You are appearing for whom?
I am appearing for respondent 10.
Who died?
Yes.
Then
Now the earlier license was up to December 2023, my lord. Now, my instruction is that his wife is applying for press license.
He doesn't have a license.
You need to get license.
What are you
after-
challenged, Mr. Monto?
My lord, it's a stone crush machine, my lord, which is established in the midst of the, my lord, the populated area. And that is
Set up and cost the order, they
My lord,
demand pass
pollution control board because of my
on
lord.
the basis of the impugn order and call for explanation for the issuing the consent order. Same is on- You are running the stone
No,
custody.
my lord.
They're running, my lord.
Presently not. my lord.
They're running.
He died in the year 2022. The license was up to 31/12/2023. Now, my instruction is that his wife is applying for a press license.
Who has given you the who has given you the instruction?
Wife is there.
What is the name of the wife?
Yes, my lord. I have the next meeting.
Give it to it. Mr. P. Hazarika, the learning council appearing on behalf of the respondent number 10 submits that respondent number 10, which is a proprietorship firm, the proprietor has expired, leaving behind
My lord, I have given his wife, my lord.
Wife and two sons,
leaving behind
mother, wife.
his wife and two sons.
Put her minor.
Uh,
17
Full Mr. Mr. T.J. Mohanto, the learned senior counsel appearing on behalf of the petitioner, submits that you do the needful. This is the matter immediately on the matter on 29th of January. 29,
29
Uh,
minutes.
29.
29 minutes. I have some.
Are you going to still appear for a dead person?
No, my lord.
Then
The matter will come up. Yes, my lord.
sir, you have already done whatever it is.
My lord.
The
Public.
death certificate of Mr. of the respondent of the proprietor of the respondent number 10 is kept on record and marked the letter.
Public. Number 11 to 18.
Long matter, eco-sensitive, don't you? And Lordship, on last occasion, 21/3/2022, Lordship directed them to produce the file along with the file affidavit justified there.
The matter stands adjourned to be listed on IMADA. The court have also taken note that these are all pending matters and as such no further adjournment shall be granted. So we still have time till another 50 minutes.
Just have a look to 21/6/2022 order first. That reflects the
21,
point.
21?
21/6/2022.
Mr. J. Patwell, appearing on behalf of the petitioners, draws the attention of this court to the notification whereby the lands which are involved in the incident with petitioner admittedly falling in inconsistent data proposed for making certain observations for the on the record that the by the notice is telling appearing on the that submitted to
Affidavit is not filed.
the You have not filed your affidavit.
But in 2004, we have filed that.
What does it say?
But that affidavit not pertain to the direction filed by the Sonobor court where the issue pertain to that notification of withdrawal. That doesn't cover.
They are withdrawing.
Lordship, earlier, they have into a particular location as a eco-sensitive zone. Thereafter, once we approached before the Sonobor court, they made a declaration before the Sonobor court on 12/5/2020 that they are going to alteration of the location.
12,
12/5/2020. One notification, that notification is there.
12/3/2020.
Yes.
Yes.
Now, afterward, my lord, what happened, the matter was pending. They made a statement before the Sonobor court that they cancelled this alteration part. Therefore, the Sonobor court on 1/3/2020 directed them to produce the file on what basis that
I'm not asking them to produce the file.
Lordship, that is the order reflects 21/3/2020 file affidavit and also produce record.
No. The respondents are directed to file an affidavit as regards the outcome of the said notification on or before so and so that the requisition, the records pertaining to the said notification be also produced on the said date.
Therefore, my lord, the affidavit which now my learned friend is relying upon,
Hmm.
that is in regard to another, my lord, writ petition,
Hmm.
where, my lord, the illegal construction etc. issue has been covered, but so far the directive given by this honorable court that doesn't reflect. Therefore, my lord, the record is necessary, my lord. Why they have made this attempt for recording of that, my lord, DC?
Why are you not producing the record? And what is your stand now? Where is the 12/3/2020 notification? Where is
My lord, in my this writ petition, yes,
that?
12/3/2020,
12/3?
12/3/2020, public,
12/3/2020. I don't have it.
my lord, what copy is there, my lord? in
Which
writ
writ petition?
petition.
Writ petition number
Followed by writ petition number 2233,
22?
335.
33, there is no notification.
Middle part.
You have a copy of, oh yes. Ah.
Yes.
In exercise of the powers under subsection 3 of the MA, the Guwahati Metropolitan Development Agency published the following notice regarding a few alterations proposed to be made in the master plan for the proposed alteration are it notified that the draft notification for certain alteration is described in the schedule upon then change of the land use along the south side of the NH bypass. Number 1 for a strip of 500 meters from Borsuk Kariyal towards Teteli up to the connecting road from Tetelia to ARC shown in the annexure remark. Area is as per the policy of the central, the developing mixed-use development along with the major transport corridors, it is proposed to change the land status of this area from the eco-sensitive to composite one, so that the planning and the proposing different from MRTC can be made commercially viable in the long run. Then, what have you done?
I need to take instruction.
Huh?
I need to take instruction.
Why you have not taken instruction? Oh, you have thought it that the matter
No,
was
my lord, actually, my lord, I thought my lord 2746 the leading case. In that case, we have filed executive matter.
Let us see 27.
46.
27.
So my
Ah.
lord,
What affidavit you have?
my lord,
What affidavit?
28/3/2022.
Ah.
My lord, in para 9, my lord, we have stated, my lord, they have made the construction without permission.
With regard to the answer,
The lordship,
petitioner was
paragraph,
issued a
lordship,
notice
I
to
think
issue
it's
the
not relevant.
investigate
Page
one
10.
after not be in response to the
Master
So
plan-
here there are two issues. They have constructed without permission.
Well-
Oh, who is paying for this?
And the plot of land is.
Tell me.
with-
An application filed by whom? Yes. How are you appearing without permission? How are you? How did you make the go down without the permission? Huh? There's a stay. We vacate the stay.
It is not that. I make the point.
No, no, no. Are you appearing in this matter?
No, I am. Yes.
No, no. 2015, there shall be no grant of adjournment. I'm told you. First of all, without permission, how could you? Forget about eco-sensitive. We are not on. And there was an eco-sensitive in 2009. Then also, when did you construct? Mr. Counsel? When did you construct?
The tail tip is of 2013.
Hmm? It is go down. Good for us. Kindly see, there are two of your reply. There are two of your that I have constructed one Asap type godown in my aforesaid plot of land by following the rules and regulations of the GMC, though I have not possessed any NOC in that regard. Then, maintenance. Yes, when are you breaking it? Before Bihu or after Bihu? Before Bihu.
Immediate after this.
Immediate Bihu. Want to have it in Bihu? It will be demolished. Forget about the NOC. We are not concerned with all this. Eco-sensitive. You have constructed in violation of 24. Why? Hello? Tomorrow at 2. Get your records. 2 o'clock. Get that record of 12:3. What is your decision? 2 o'clock. Hard in part is the matter tomorrow at 2. This matter can't remain for such long time. एक को नहीं agreement why को action wise पड़ा. It's disgraceful. I think yes, madam. There is a serious complaint by this court. Whenever the matters of animal husbandry are there, you are not to be seen. There are many matters yesterday, day before yesterday, all these matters you are not there. Matter where I fixed it on a particular date. Just get it from your government council. Animal husbandry. Yes, I still remember. This matter was, I think I fixed it on 22nd of January. This was a matter where 1,61,000 was the amount you have withheld because he was involved in the LOC scam. Then that matter, that LOC scam he was acquitted. And as such, he has asked for this amount. There has been no instruction, nothing. Yesterday, matter came. It is a matter of 2015 or 16. Find it out.
Horenborg had better. Perhaps my name was not
Huh?
reported in the list. Yes, my lord. Perhaps the
I've
petitioner was
asked
Horenborg.
an order to show your name in the
Fine.
list. You just find it out.
I am
Yesterday,
Mr.
the
Horenborg.
matter was there.
The petitioner was Mr. Horenborg who had better.
Maybe something. I don't remember. I don't know petitioner's name. I only remember the facts out there.
Yes, my lord.
There's some 1,61,000. was
My
there.
lord, LOC was
Well,
there, my-
only instruction is as to whether the person, the petitioner was not represented. Petitioner must have left. So only instruction required is as to whether he has got the money or not. Only reason why you have withheld out there categorically is because he was involved in LOC scam. Now that LOC scam, he was acquitted. That is the order which have been included. So nothing.
But in this matter also, my lord, this honorable court asked for the disciplinary proceeding, record of the disciplinary proceeding, my lord, as to whether this petitioner was
given a chance to represent himself in the disciplinary proceeding or not. Till date, my lord, we are not pressing the record. It's a record of 1992. The department is the record of the disciplinary proceeding yet.
Huh?
So far, my instruction is that 2 weeks time may be allowed, lordship, for the
8/7, your
original
lordship
record, my
directed
lord.
on July, 6
Lordship,
months back, to produce the record, whether, my lord, pursuant to the inquiry report, he was, my lord, allowed to represent. Thereafter, matter came out 8/8, after a week, after a month, my lord. My lord, time was again sought for on the ground that not present. By this time, 6 months have expired.
my lord, it's a 1992 matter. So it's difficult for that only.
No, he was transferred, means,
My lord,
1992, my lord.
96, my lord, the
96.
order was passed.
then order dated demand asking the petitioner to furnish his reply against the decision of the government to withhold entire pension, including gratuity for the alleged misappropriation of the money of demand. Petitioner submitted his reply denying demand. It has been decided by the government to accept the inquiry report and recovery of misappropriation. The governor is free to also withholding of withdrawal of nine against the recent judgment has come. You've seen Justice K.V. Vishwanathan judgment, wherein it says that if it is exactly on the same facts, then the disciplinary proceedings cannot go. If it is exactly on the same facts. No, that is what I'm saying. Wait, let me give it to you. It's a very recent judgment.
That's not happened.
This judgment was rendered in the case of Ramlal versus State of Rajasthan. Okay.
Fine.
I give it to him. You can take it from him, huh?
My lord.
This was given on 4th of December 2023. Here it says, it- it says that normally in both cases, parallelly it can go. But if it is a case where all the evidence are the same, then in that case, continuation of the disciplinary proceeding after being acquitted, you couldn't have it. Normally, you don't get that type of judgment. This is a very recent judgment on this point. I think this is the judgment. Anyway, your pension has been stopped, na?
My lord, entirely withheld, my lord.
Although you have been acquitted
I've
on
been,
the same fact.
on same amount, the amount of. And in fact, on proportionality also, proportionality also, my lord, not to be interested.
No, in fact, this judgment, because I remember I kept this judgment out here only for the purpose. I think it is still lying in my table out there. The SCC citation is also there. SCC online. It's given on 4th of December. I still remember because this matter came up before me earlier, no? So I remembered that. So this is why this is exactly on the same point. That if the evidence or the witnesses, everything are the same, then there is no, it would amount to an abuse of the process. If that be so, we can set aside. If they are not producing the records, we can't. Isn't it? Pension and all these things, you can't stop it. When?
Before, my lord, he gets my lord, pension now 78 years old, from 96, my lord.
You get this,
I'll get it, Ramlal, I'll get it.
he can give it to you.
Right.
I think there is a Justice Vishwanathan judgment. This is the judgment.
Right.
I have many matters on 11. No?
Will hardly take, well, yeah, what will letter on.
Let me have it on 18th.
It is already part of that. What will letter, my lord, on earlier
They have
order,
not shown it for years before. Yeah, it has been shown. Okay. 18th. Let's have it on 18th.
what will the order in? That's it.
List the matter also. This court had on various occasions since the month of July have sought for the records pertaining to the disciplinary proceeding. However, the records have not been produced. It is also pertinent to mention that the petitioner now is 78 years old, and a further delay in disposal of the instant writ petition, which touches on his pensionary benefits, would be not in the interest of justice. Accordingly, this court fixes this matter on 18th of January 2024 for further consideration at 2 p.m. A last final opportunity is being granted to the petitioner respondents to produce the records.